I request for a short accommodation case.
I appear for respondent 9 and 10, my lords. The matter is with respect to lands being come whether forest or not, my lords. Already, my lords, 1986 yellow zone, government themselves have declared as yellow zone. The short question is, our land excluded by way of notification is genuine or not? Government has given a reply that it is a genuine, my lords.
My lord, to be sorted out. My lord, today the learned advocate general is a little inconvenience. If my lord could have it any other day.
Twice, my lords have fixed this at
No, we are
2:30
not
p.m., my
denying
lords, to
that, sir. We are
consider
not
this.
denying. Obliged.
Let's like short date, my lords. Humble request, my lords, because in view of them having considered this as forest land, no layout construction permission is being granted. May I request 2:30, my lords, at 20. I'm grateful.
My lords, may I be permitted to make a small mentioning, my lords?
Madam,
My
you
lord?
mention after the physical mentioning. After physical mentioning is over.
Oh.
What do you want? What do you want?
Serial number 96.
What do you want?
Short date, my lord.
Date. Date will go then. Will go to 15th April.
Lord's entry order may kindly.
No, then we will not extend. Why you are seeking time?
Serial number.
Senior is out of station, my lord.
The order granted earlier. So continue.
Serial number.
Memo for
19.
being spoken to.
Serial number 19, my lord.
19.
19. Senior is not doing well, madam. 2 weeks.
Here is not PIL. No, this will not grant.
Next week.
My lord, in this I will file the order passed by the special DC, my lord. They can look into it and on the next day they can make a submission.
Next week.
Proceedings under section 136(3).
4th March at 2:30.
Serial number.
My lords, memo for being spoken to. My lord, yesterday, my lord, at the time of hearing, my lord, we have made submission that the matter is pending before the Karnataka State Appellate Authority for Forest and Environment, my lord. Due to the want of chairman, there was no sitting, my lord. So that is we have mentioned, but the council for the Karnataka Pollution Control Board has stated that the last week there is appointment of chairman. They have stated, my lord. But when we cross-checked there, when we verified, the authorities there stated that there is no appointment of the chairman.
Your Lordship, sincere apologies. The council understood the appointment of the chairman of the board, Your Lordship. Sincere apologies.
We categorically specifically mentioned,
The authority, please, Your Lordship.
we have mentioned,
Please,
my
Your
lord,
Lordship.
that on the ground of want of chairman, there is no sitting. We have filed the petition.
If it is not signed, then we will not sign. If it is signed, see that it is not signed. It's not. I don't know whether it is signed. If it is signed, then we will permit to move the being spoken to. If not signed, we will not sign it.
Sincere apologies, Your Lordship. Apologies, Your Lordship. My lord, there's a
Chairman, you are making a statement before the High Court.
my lord, there's a writ appeal, my lord. There's a fresh
Yes.
writ appeal. There's an SC/ST matter, my lord.
Which one?
It's a new matter. I'm moving a memo for a fresh matter, my lord. But earlier moved a memo. Your lordships had given me a date of 4th February, my lord. However, the matter did not come up, my lord. Despite your lordship giving the date, my lord. There's grave urgency in the case for the reason that I'm a Dalit farmer, and every single day there are
19th March.
19th March. Of that.
But
serial number 26,
Serial
ma'am.
number 8.
But serial number 20.
Serial number 8, 2 weeks later.
It will go to 2nd April, 1st, 3rd April.
But serial number 26.
My lord, my lord.
26,
Right. Serial number 41. Next week, my lord, AG appears in this case, my lord, for the respondent.
It will not, no, it will go to
Next week,
7th April.
My lord, I appear for the complainant. I oppose in 41. May I request for it to be taken up? May I request for 41 to be taken up?
You are for complaint.
I'm for the complaint.
I am for the respondent, my lord. Advocate General instructed me to take, my lord, a week's time, my lord. He appears in the matter. Advocate
Let
General.
us see what is the schedule. That is- When it is called out, you may renew your request.
Serial number 67, my lord. 67 and 78, my lord. These are the BWSSB matters, my lord. And connected matters are listed on 7th March, my lord.
7th March, 67 and
78.
70.
My lord, an IA has been filed.
Yes.
78.
My lord, serial number 34, my lord, 34. I pray for 2 weeks' time, my lord, in this matter. I appear for the petition.
We'll go to 15th April.
Please.
26
Lord,
minutes.
Serial number 43, my lord. I need to file objection, watchman, and 2 weeks time, my lord. I informed the other side. 43.
43. 27th March.
Fourth.
My lord, serial number
26, my lord, serial number
Wait,
26.
1 minute. Read.
70, 76.
76, my lords.
ನೀವು ಸ್ವಲ್ಪ ಇದ್ರೆ
I seek for a week's adjournment, my lords.
ಯಾವುದು?
24th March.
Grateful.
Serial number 13, my lords.
26, my lords.
26.
We have to seek instructions in this, my lords. I'm appearing for BPMP. Respondent number 1 to 5 in this matter.
This PIL.
Yes, my lord.
Let us see. When it is called out, you renew it.
Yes,
We'll see what the matter is. Yes.
My lords. What has happened during the pendency of my contempt of disappearing was filed with this case. Subsequently, disappearing was dismissed after hearing. And along with the petition, my contempt also was closed. By giving 4 weeks time. After 8 weeks also they are not complied. Hence, I am finding an IA. Already found an IA for revising my contempt.
26th March.
Serial number 45, my lord.
Serial of contempt matter, my lord.
26th March.
Serial number 13, my lords. I pay for 2 weeks time, my lords. Without a accommodation, my lords. We have informed the other side also, my lords. I am appealing for petition.
Other side is informed.
I informed, my lords.
25th of March.
Oh, Lord, serial number
Serial number 45, my lord.
38, that ground matter, my lord. We engaged ground matter. PIL, the senior counsel is not in station. We engage a senior counsel. Senior counsel is not in station.
Serial
Both
number
the AG also
45,
is
my
not-
lord. Serial number 45, my lord.
AG is also not there.
Maybe.
Serial number 40.
Noted.
Senior counsel is not in station. We engage senior counsel.
Said no. When it is called out, you may renew your request.
We engage senior is not in station.
When it is called out, you renew your request. Right?
Serial number 45, my lord, for the complainant.
Okay.
2 weeks, maybe.
45.
45, my lord, for the complainant.
2
We
weeks.
have invited the other side also.
4th April.
Much obliged.
What is the urgency?
My lord, the respondents are trying to create third party rights over the schedule. Earlier I had moved to Matthew, but it has been
18th March.
My lord, serial number 60, my lords.
60.
Yes, my lord. Kindly be adjourned for the 2 weeks, my lords, because my senior is unavailable due to his mother's ill health. So,
When shall it be?
2 weeks, my lords.
2 weeks. 25th of March.
Job rest.
Serial number 13.
CL number 39, my lord.
30.
39. It has been complied, my lord. Contempt may be dropped.
Notary 39 complaint.
So you time.
Complied, my lord. Contempt may be dropped.
4th March. 4th April.
May be dropped, my lord. Contempt has been complied. The order has been complied. It may be dropped, my lord.
Oh,
Yes.
learned advocate, Mr. KV. Simhan.
Satyadi.
Jani for learned KV has stated that the order under contempt is complied with, therefore the present proceedings are survive. Any of the statement of learned advocate for the complainant. The contempt petition is dismissed as not surviving. Yes. Yes.
I am filing a memo to consider a matter for admission on tomorrow. Commercial appeal, Your Lordship.
Commercial appeal will not come here.
Rose to bench.
Before this.
Any other mention through VCs? Contempt matters. Skill number 1, Chandra Kumar R.
My lord, I am appearing for the complainant. My lord, there were case and counter cases filed by the complainant and accused. Thereafter, on 18 November 23, both the parties were filed joint memo before the Honorable Court, single bench, to withdraw all the cases pending before the trial courts filed by the respective parties. Despite the facts, though the accused was agreed to withdraw the cases filed by him, was continued. Thereafter, after dragging the matter, after failing the objections, word order dated 3 cases came to be dismissed. Before filing the, after filing the contempt petition.
So what is to be complied with? What
He
is
had,
to be,
accused was agreed to withdraw all the cases filed by him.
what
Against
is
the
to be
complainant.
complied with? You show the direction
Right now
or
he
the
has
con- or the consequential compliance. So where is that? At which page?
right now he has withdrawn all the cases, came to be dismissed. Right? After
This is a-
filing the after filing
This
this
is a
complaint.
contempt petition, you straightway go to the direction which are to be complied with. No here and there.
He
Which
was,
are the
since-
direction to be complied with? Either direct or consequential.
like, he was given undertake to withdraw cases filed by him before the trial courts.
What undertaking? Where is that undertaking? And where is the recording of the undertaking?
Annexure A, joint memo. Annexure A, my lord. Page number 14. Para number 3, 4 and 5. Since he was failed to withdraw the cases filed by him, learned trial judges passed the orders in page number 80, Annexure K.
It is only about the withdrawal of the respective proceedings.
He was agreed to withdraw, but he did not comply. But on the merit, trial court has dismissed the cases after filing the complete contempt petition.
There is no contempt. Notice returnable on 16th April. Next.
Acceptable.
Skill number 2.
I appear for the explanation. The order that has to complete is annexure B, my lord. The relevant portions at in page 20, in page 20, my lord. The respondent shall consider the application, the respondent and pass appropriate in accordance with law, consequentially pay the applicant such salary as attached to the post of food safety officers. It is made clear that despite the decision made here in above, and in view of the fact and on pain of the declaration, the appointment have been sought, the observation with regard to the appointment are clarified as not considered and be open to the consider take such action as permissible under law. In the event respondent comes to the conclusion, the decision that the applicant is not appointed to the post of food safety officer according to the FSS Act within a period of 3 months, and the consequential relief shall be released to the petitioner at the earliest,
Notice
not
written
late than
15th
1
April.
month outer.
Notice 15th April.
Pardon. Bill number 3, pardon, my lord. Vasant Kumar.
Notice.
Obliged.
Complaint by me. Yes, what is it? Delay.
Order passed with the learned
There is
single
of
judge.
which year? Order of 2020.
Page 14, my lord.
The direction.
There was a direction to execute the sale deed within a period of 8 weeks. Being agreed with the said order, he has preferred the writ appeal. Withdrawal came to be dismissed on 9th February 2023, annexed D, my lordship. Thereafter, the matter was referred to the alternative committee to execute the sale deed. They have not done so. Impugned order passed with the learned single judge annexed Yeah, page 14. Page 14, para 10.
Correct.
There was a direction to execute the sale date.
Order is of which date?
Yes, are being agreed.
2019, February 2019.
Yes, no. Thereafter, Mala, the content was fine. Then the pendency of the control annexure C.
Contempt was filed in 2020.
Yes,
It's
ma'am.
ended up with the
Yes,
order.
ma'am. There, during the pendency of the content, the writ appeal
19th
was
March
fine.
2020.
Writ appeal was fine. So writ appeal came to be dismissed on 9th February 2023. Thereafter, my lord,
Which writ appeal?
he was admitted in the hospital, produced the medical report.
Which writ appeal?
Pardon, my lord?
Which writ appeal? Where is that order?
My lord, the annexure D, page 18, my lord.
Yes. So what was that writ appeal? What was the writ appeal?
The contention urged by the applicant before this court did not arise for consideration before the learned single judge. And therefore, we are with the view that it is not required for us to advert this contention as learned single judge has only directed the reconsider representation submitted to the respondent, and it is needless to state that such re-representation, the representation is required to be made in accordance with the, under these circumstances, we do not find any merit in this appeal. Accordingly, the same is dismissed. The order of the learned single judge is confirmed for
Will not extend the 1 year time.
No, my lord, he is admitted in the hospital. My lord, I produced the medical report.
That is no ground in contempt, dismissed in view of section 20.
No, my lord. The annexure, I produced the medical report.
It doesn't
Yes.
help. There is no section 5 limitation in contempt.
I'm relying that Supreme Court decisions, my lord, there is a the delay may be
Your
converted.
right terminates once the 1 year is over, on the date of cause of action to file the contempt.
On the short may be accommodated. I'm relying the apex court order for condoning the delay, my lord. Because he's been
There
admitted.
is no delay. It is not a concept of delay. Yes, next.
No, there is a direction from the learned single judge to execute.
See section 20 of the Contempt of Court.
Yes, this is
Read
one.
Read it. Give to it. Read loudly for your satisfaction.
Limitation for action of contempt. No court shall initiate any proceedings of contempt either on its own motion or otherwise after the expiry period of 1 year from the date of which the contempt alleged to have been committed. But
when the contempt was said to be committed in 19, after the time to consider the
no, writ appeal came to be dismissed.
writ appeal will not, other side writ appeal will not extend the time. Sorry.
No, not being the being agreed by the order of the learned single judge, the BDA has prepared the appeal.
That will not extend the time. We'll say, hold that. Yes.
No, my lord, after giving directions, immediately contempt was fine. You know, annexure C may kindly be seen, my lord.
Even otherwise, 1 year has elapsed.
Yes, I do agree, my lord, because in the earlier contempt petitions, the contempt was dropped only on the ground that to challenge the endorsement. Immediately they filed the writ appeal, they got stayed. Stay the further proceedings of order passed with the learned single judge. Only after dismissal of the writ appeal, the present contempt is filed, my lord. There is a lapse of 1 year because he is admitted in the hospital, I produced the medical certificate also, not so.
That's all. Yes, next.
Number 4. Mr. Pradeep Nair.
This is that. Trees matter for.
Which one?
For permission to fell trees of BMRCL, IA number 8.
The last occasion, your lordships had.
So why it is kept, some order was passed.
Your lordships
What
had
is that
directed
said?
BBM, sorry.
BPSP
directed-
to find out whether.
They've now filed an affidavit.
What does it say?
They've identified locations where we can plant
Very
trees.
good. That's good.
They have identified locations for 50,000 trees within the city, my lords.
Very good.
You are supposed to.
610 in
610.
this OM, but 35,000 trees are still pending from the previous
35,000.
orders.
20,000.
35,000 according to the filings that have been made.
No.
This one, this specific.
For this,
You are supposed to replant how many trees?
10 trees.
610.
610.
610.
Only 610.
Only 600.
Manoj, there are 35,000 trees pending from previous orders, which have not yet been planted.
All of it
Those may
planted.
also be directed to be planted within these areas which have been
91
identified.
locations were about 50,000 sapling, very good.
Please, my
So this will.
It's a good thing.
So we'll allow this.
Yes,
please, my
Lordships may.
Let's-
Which is that IA
I have three
IA
subjects.
number 8, my lord. IA number 8 of 24.
So we'll say that the BBMP will intimate you about the.
Yes, the locations are
that you
here.
have to carry out.
My lords, two submissions on the process, my lords. The BBMP is supposed to do soil testing on these locations to ensure that as per orders of 15/7/2021 of this honorable court and 29/7/2021, they have to,
Which are the orders?
15/7/2021
15/7/21.
and 29/7/2021. Soil testing report is to be done. BMRCL is supposed to say which trees are being planted, which species of trees, because there are a number of trees which are permitted and which are not.
So again, the tree expert committee has to undertake the.
Please, Your Honor. Then the tree officer,
We'll say within 1 month,
please, Your
Beg your
Honor.
pardon, my lord?
the committee shall undertake the exercise
Another
of
15 days it can be done, my lord.
15 days.
Please.
Only 600 trees. are
Only
there.
600.
Your Honor, even the 35,000 trees also have to be done, the pending trees, for which no action has been taken.
35,000.
Not the subject matter of this.
Not this subject matter.
Well,
but
it's
that
subject
also
matter
we
of
do.
previous orders that they are not in compliance with, identical orders over the last 3 or 4 years.
Don't mix up with this.
As if they continue in this fashion, then they will never comply, my lords.
You are there to file INI.
We have a good watchdog, my lord.
You can file IN, we'll deal with it in accordance with.
That's what I have filed, my
Not
lords.
in this
Not
IA
this,
number
sir.
8. How can we deal with that aspect in this?
We have filed a memo highlighting the series of non-compliances with this court's
Or you
orders.
want to seek some relief, you file IA. This will not mix up. We'll allow IA number 8.
Yes.
With this
Great.
condition that within 15 days, the tree expert committee will survey they will intimate, then the area will be surveyed. for the
And
purpose of-
BMRCL has to intimate them as to what species of trees are being
Correct.
planted.
Yes.
There's one more clarification I had sought.
Yes.
The plantation, as I had said, was delayed by them in some cases for 2 years.
We are doing.
That's fine. Just that this honorable court had directed 3 years, they have to ensure that the tree survives. Your lordship may clarify that obviously the 3 years starts from when they are planted, not from the date of the order, because their compliance takes it from the date of the order. Sometimes, my lords, the date of order is passed, they plant 2 years later, and within just 1 year, they say 3 years are completed.
Which 3 years are, which trees are to survive for 3 years?
The afforested trees, they have to check quarterly for
Monitor
3 years.
We have
Please,
to maintain them for 3
they have to
years.
maintain it for 3 years. Your lordship may clarify the 3 years starts from the date of planting.
Bound to be.
From the date of plantation.
Bound to be.
Because they're calculating it from the date of order, despite planting 2 years later.
When there is no tree on the date of order, raise the question.
30, that's,
No.
my lords,
No, if
that's how they have
If
filed
that's what
that.
they've said, it's wrong, my lord. It's 3 years from the date of planting. I'm sure from so.
Please,
now.
but the quarterly report showed it the other way.
Anyway, take the
We'll-
details of plantation.
We'll do.
Thank you. Grateful, lords.
Provide.
Oh, perfect.
18,340. 18,343.
18,900.
This is correct. This is correct.
ಇಲ್ಲ ಇದು
ಹಿಂದೆ ಮುಂದೆ ಇದೆ. There are 2 pages. Sir. Both the same.
22 days. IA number 8 is. It may be listed on 21st April, main process.
Deeply
Yes,
obliged.
great.
Cell number 5, it's a green bench matter, Mr. Sagar BB.
My lords, kindly pass on, my lords.
Why?
Proxy counsel, my lords. The on-record advocate is ready in the matter, my lords. He'll argue in the matter. Kindly pass on, my lords.
Not corrected copy of the writ petition has not been served on.
My lords, I'll serve the copy, my lords.
The prayer you are making, you must supply the copy. Only to consider the supply, day after tomorrow.
Day after. My lords, kindly pass on, my lords. See, they're ready.
Supply the copy, they don't know what is your petition.
Grateful, my lords.
Appeal number 6.
Would I appear for the appellant in this matter?
There is a delay also,
The delay,
22 days delay.
21 days.
What is it about?
My lord, this is in relation, my lord, to actually originally a Lok Adalat order. But my lord, there was a change circumstance. The change circumstance was the company went into CIRP under the Insolvency and Bankruptcy Code. After it went into CIRP, CIRP failed. Then it went into liquidation. During liquidation, my lord, a scheme of arrangement was proposed. Under the scheme of arrangement, my lord, there are various claims that are made to the liquidator, and the liquidator considers those claims, and thereafter determines the total claims that are there against the company. The scheme of arrangement deals with the manner in which all claims are taken care of. And therefore, my lord, there is an extinguishment of all claims of all debtors after a certain period.
Yeah, the subsequent development.
That's a subsequent development. That is placed before the learned single judge.
There can be a ground to review.
Beg your pardon, my lord?
You can seek a review from.
No, it was placed before the learned single judge. It was not a subsequent event after filing of this appeal. It was, my lord, as a matter of fact, during the pendency of the proceeding, there was a moratorium, my lord, prescribed under the Insolvency and Bankruptcy Code under Section 14. So the proceedings could not go on. Then the company went into liquidation. Once the company goes into liquidation, my lord, there are two scenarios which could emerge. One is the assets are sold by the liquidator, or a scheme is evolved in order to take over the company by a new entity. So a new entity came into the picture, proposed a scheme of arrangement, and provided a mechanism of repayment of debts which will not are permissible to be paid, under which, my lord, all debts which are there have been extinguished. And that receives, my lord, the approval from the National Company Law Tribunal. Once that happens, in law, all other proceedings and legal claims, my lord, come to an end. The learned single judge, my lord, says there's a distinction between claims and claims which are adjudged and become a judgment decree or a decree, like, my lord, a proceeding before the Lok Adalat. That, in my respectful submission, is contrary to the scheme of the IBC code itself. Therefore, once, my lord, a new entity took over, the new entity made an application to substitute it in the place of the petitioner to place these facts before the court. The court then, my lord, says, no, you are still liable to pay, notwithstanding the provisions of the IBC code.
We'll hear the matter. Today we condone the delay.
Your Honor,
We condone the delay today. You are for whom?
respondent,
Which respondent?
respondent is respondent number 1.
That is,
Respondent 2, they have cited
Done-
as a pro forma respondent.
number 1 is Dhanvantri,
Dhanvantri Steel.
and who is for number 2?
No one.
No one.
No,
Then
no one
notice
has come.
will have.
No, you may dispense with notice to respond number 2, my lord, because they are really an ex-director of the company. That's all. That all the directors not cease to.
So IA number 1 of 24. At the outset, learned advocate for the appellant, learned senior advocate, Mr. Dhyan Chinnappa, submitted that respondent 2 may not be a necessary party, at least for the purpose of this application. Therefore, he seeks to delete number respondent 2 from the area of the respondents. Permission is granted. The head respondent number 2 stands deleted at the cost of
The Lordship may kindly appreciate,
full stop. Heard learned senior advocate of the applicant and learned advocate Mr.
kindly appreciate
So and so.
that
for this
the
applicant.
respondent number
Full
2,
stop.
who has been arrayed as pro forma respondent, he is actually the signatory of the check which was dishonored. He is actually the petition number 2 before the court below, and they have cited him as a pro forma respondent.
It's up to him to file.
This case arises, Your Lordship, from a dishonor of a check under Section 138 of the NI Act. What my learned friend is trying.
Why don't you serve them?
Beg your
What
pardon?
my learned.
Why don't you serve number 2?
You can serve number 2, my lord. It's all right. We'll serve
Notice
number.
returnable on. We'll give it short date.
Yes, ma'am.
So 19th of March. Service to respond to is remitted by hand delivery.
Handed.
Full stop. Learned advocate Mr. So and so accepts notice on behalf of responder 1. So let there be notice in both appeal as well as in.
Very well. think your lordship had granted interim order last time.
Is granted regarding cost.
And no, Your Honor,
Your lordship had-
kindly appreciate no interim order was passed.
Regarding
Direction
cost,
was given that we shall not perquisitate the matter.
not precipitate.
That's all, Your Honor.
It is
Your
already
Lordship
there.
may kindly, I would like to just take 2 minutes, Your Lordship. This is not a claim made after the resolution proceedings or the IBC court. It's a criminal case under section 138 of the NI Act.
We'll hear the matter, not that.
So it is not a claim what they say in a civil suit. If that was so, whatever he says is okay.
So it is not limited.
I'm sorry.
Relief is not limited. The observation is not till today.
I'm sorry.
The observation regarding this precipitative steps.
Yes.
Is not limited.
Not limited. Oh, sorry. Great.
Bill number 7. Writ appeal, Mr. TP Mutana.
So
I
delay,
appear for the appellant, my lord.
delay notice renewal on 16th April.
Great, sir.
Yes.
8 is urgent, Bill number 9. To Sudesh Kumar Acharya.
Delay, I filed the application with reasons, my lord. To condone the delay, I have already filed the application, my lord. And
You are
he
there.
he is representing the central
The
government.
only person.
Please.
What is 236 delay? Heard learned advocate, Mr. IA number, number 7, IA number 1 of 20. Heard learned advocate, like Mr. So and so for the applicant and learned additional Solicitor General of India. Shanti Bhushan. 4. This one, 1 Union of India, and this one 2 to 8 were the authorities of authorities under the Union of India. There is made in this application to condone the delay of 236 days, which has taken place in preparing the appeal. Full stop in the accompanying affidavit. The passage of time leading to the delay explained by stating that after the deliverance of husband and order of learners in business, certified copy was applied and the same was received by the appellant on 31/10/23. Post of the copy was forwarded to the head office. Purpose of deciding the next course of action. Post of it was learned advocate on the wage of the government's men in the head of the submitted that the decision was eventually taken for filing the appeal. However, before the decision could be finally taken by the head office, some time elapsed in processing the case, which led to delay of 236 days. It was submitted that there is no element of negligence. Considering the aspect that the appellant is State Bank of India, which is an impersonate body, it cannot be said that delay is intentional or deliberate. The time taken in processing the papers for the purpose of filing appeal has resulted into delay, which signifies sufficient cause. In the above view, the application is allowed by dealing condoning delay of 236. Now, what about the appeal?
My lord, this is a matter, my lord, that Provident Fund Trust of State Bank of India, they invested in because
Some other day.
no this one because for fraud. And it is only for interest, my lord.
Some other day, 24th of March.
Great.
Eight is urgent, number 9. Mr. Sudesh Kumar Acharya.
Make the appeal for the appellant.
Yeah.
Well, in this case, my lord, an attempt is made by the respondents number 3, my lord, to defeat the earlier order passed in the writ appeal before this court, my lord. Annexure K is the order, my lord. Page 113. The issue regarding, my lord, determination compensation amount is reached up to the earlier round of writ appeal. Well, in this case, my lord, the issue has been concluded, stating that, my lord, it is now the remedy is only for the reference officer to disburse the compensation amount in favor of the appellants. Now, kindly look at this order by Annexure K, my lord. It will conclude the issue, my lord. My lord, page 115. May I read, my lord?
What is it? Page annexure K. What you are showing?
This is the order passed, my lord, the writ appeal page 113, my lord. Writ appeal order. In this, my lord, the para 5 honors, you will also kindly see, para 4 honors, brief facts. In view of the dispute between the owners of the lands, a reference was made and the case was registered in LAC so-and-so before the so-and-so court. The private respondents filed IA number 2 under Order 1 Rule 10 read so-and-so seeking implement in the proceedings. The said application was dismissed. Feeling aggrieved, they challenged the said order in MFA so-and-so and withdrew the same to present it before the jurisdictional court at Udupi as the appeal was maintained before the learned district judge Udupi. Sri Acharya submitted that after withdrawing the MFA from this court, the private respondents did not file any appeal before learned district judge. Hence, the order in November so-and-so 2009 rejecting INOD and the judgment award passed by reference court attained finality. He further submitted that after withdrawing the MFA, instead of filing before the learned district judge, private respondents again filed objections before the Special Land Acquisition Officer as per Annexure G. And as per the order at Annexure A, ordered that the compensation amount distributed to the petitioner and the private respondents. The petitioners challenged the said endorsement in the instant writ petitions. The Honorable Single Judge has set aside the order passed by the SLAO. However, directed the SLAO to refer the matter again under Section 3031 of the Act for adjudication to Kenya. Sri Acharya argued that adjudication was completed by the reference court in LAC so-and-so and the award passed on November 6, 2009. The claim of a private respondent has been expressly rejected and the said order has attained finality. Therefore, the later portion of the order passed by the Honorable Single Judge directing the SLO to refer the matter under section is not sustainable in law. This is the P.V. Chandrasekhar who appears for the KADB. He also consented. P.V. Chandrasekhar, learned advocate for KAB, submitted that the order of the reference court in LAC has attained finality. And therefore, what remains is filing an appropriate voucher before the LAC court and to withdraw the compensation amount. According to him, the direction issued by the SLO by the Honorable was not sustainable, by which, my lord, the private respondent have stated in Annexure G that they were not desirous of filing any appeal before the learned district judge after withdrawing the MFA. Therefore, what remained was only disbursement of the award amount. However, the SLO has again order for apportionment as per contrary to the judgment. Writ appeal is allowed in part. Pursuant to this order, my lord, the reference court, my lord, has passed an order. That is, my lord, LAC order is available at, my lord, page 48, my lord. That is after the order direction issued by this court, my lord, the SLAO, the reference court passed an order by closing the proceedings. Kindly look at this, my lord, the operative portion at page 64, my lord. Operative portion, page 64. The reference petition made in section C by the referring is disposed of in view of the observations made in MFA number dated, writ petition dated, and writ appeal number dated by the Honorable High Court of Karnataka with the following terms, by which, my lord, I have been directed to be disbursed with the compensation amount. This order, my lord, has been put to challenge by the respondents 1 and 1 to 3 before the learned district judge. My lord, learned district judge, my lord, despite this fact has been brought before him, my lord, he admitted the appeal and granted the stay of the reference court order, which is the order has been challenged before the learned single judge here once again, my lord, stating that the appeal itself was on the face of it was not tenable. It's an abuse of process of court, my lord, defeating the order of the writ appeal. My lord, learned single judge, my lord, instead of, my lord, entertaining writ petition, directed the learned district judge again to go on with the matter. It's a clear abuse of process.
This is different appeal. Yeah, before the
writ appeal is passed, my lord. Writ appeal is passed.
reference case is different.
No, same case, my lord. Same case. Reference case is same case, same between parts. That is why reference court has observed that I have to follow the division bench order of the High Court.
So
There is nothing to be inquired into.
You can point out to learn a single.
Pardon me, Lord. I have pointed out the ground surgery before learner single. You will also kindly see the ground surgery before the learner single. Kindly see the writ petition.
Same fate and then further remedy will go.
Pardon me, Lord.
Your case will meet the same fate.
No, learner single judge, my lord, learner single judge should have set aside the order passed by the learner district judge, my lord, stating that there is nothing to be decided by the learner district judge. Hence, my learner single ought to have entertained the writ petition, my lord, by rejecting the appeal, my lord, and directed the reference court order to comply, my lord. That should have been done. Learner single judge did not go into all those aspects, my lord. Even, my lord, the learner single judge did not look into the division bench order passed earlier, my lord. So we say abuse of process, once again going to the proceedings. Well, there is nothing to be decided to hold an inquiry.
Counsel, do you mean to say against LAC number 99 of 2013?
Yes.
It is impermissible in law to file MA number 11 of 22?
Well,
I'm asking you this question, yes or no?
My answer is, my lord, MA was not permissible as per law for the reason, my lord, this reference court as in the LAC has simply followed the direction issued by this honorable court.
Counsel, against the order passed by a civil judge, senior division in LAC.
Reference case.
Yes, reference case.
Yes.
MA is there or not? The remedy of miscellaneous appeal is there or not?
Well, remedy of appeal, I don't deny, my lord, because remains is,
MA is there.
MA is there.
MA is there.
Well, granting the stay order, my lord, giving a go by to the order passed by this honorable court, my lord.
Whatever, right or wrong.
Well, rightly or wrongly.
Put it on an appeal. Now, that will be examined in MA proceedings itself.
That is not necessary, is my respectful submission, my lord. Because of the reason, writ appeal, issue has been concluded.
Now, this order was passed on 30th October 2024.
Yes.
3 months time was granted. What has happened in MA? You could have pursued it over there instead of filing the writ appeal.
My lord, because my endeavor was, my lord, in the writ appeal, when the issue has been concluded, well, the finality, there is nothing to.
Can't you produce the same?
I produce and I have pressed it into service.
What has happened in MA?
MA, my lord, the learner district judge state the reference court's order.
Now what is the position?
Well, because this honorable court, my lord, while entertaining the writ petition, they state the proceedings of the MA order in the writ petition.
In the writ petition has been finally disposed of.
Now finally disposed of.
This writ petition was disposed of on 30th October 2024. With the direction that MA has to be decided within 3 months. What you did after obtaining the writ petition copy?
My lord, my lord, the endeavor before the honorable court was, my lord, there was on account of the writ appeal order, my lord, there is nothing to be decided, my lord.
So you have not gone and pursued your remedy before the district court?
I did not, for the reason, my lord, I would be getting the relief in pursuance of the writ appeal order. Because my learner single ought to entertain the writ petition, taking into note of the writ appeal order.
That is exactly.
Pardon me, lord.
We are not entertaining. Dismissed. You go whatever remedy you have. Very apparent that this appeal cannot be. Yes.
My endeavor was, my lord, only to see that, my lord, the order passed by this court in the writ appeal would be, my lord, honored. Because, my lord, the reference court has given respect to the division bench order, my lord, because the issue has been concluded.
That you can point out to learn a single.
My lord, may I make one submission? Now that, my lord, this has come, with the hope that, my lord, the order passed by this court in the writ appeal would be sustained. And, my lord, may I request your lordship to direct me within a month of, because for 14 years I have been, my lord, lagging behind this issue. From 2009, my lord, the respondents prevented from me from taking the compensation which is fallen to my share. 14 years I have been lapsed.
What is to be directed?
My lord, the learner district judge will dispose within 1 month from.
You go there.
So that, my lord, I have been lagging behind this, my lord, for 14 years, my lord. 2009 issue has been going on.
Withdraw and then we'll make up. Not well dismissed.
He doesn't go there, he doesn't pursue his remedy there. He wants to prefer right appeal and agitate the matter.
Pardon, my lord.
Learned Singhal, you already said 3 months.
Oh, that is there, my lord, because
Filed away the time and
That-
came here.
then because
You boarded a wrong bus,
I have to, I have,
a special bus.
well, I have to safeguard, my lord, because order passed in my favor in the writ appeal. I have to obey that.
Next.
Well, maybe 1 month, my lord, 1 month time.
You withdraw, then you go, we'll make up. You
Well,
withdraw.
with liberty to.
Learned advocate, Mr. So-and-so seeks permission to withdraw the appeal.
1 month, my lord.
Seeking liberty to approach the competent court below in respect of the subject matter. Full stop. It is already pending.
It's already
This
pending.
is out of.
MA is pending, my lord. MA is pending.
His remedy for MA.
Learned advocate, Mr. So-and-so seeks permission to withdraw the present writ appeal. In view that the miscellaneous appeal is already pending before the competent court, he further requests that the said proceeding may be directed to be concluded expeditiously, full stop. The request is not unreasonable. If the request is made in writing by the appellant herein before the court concerned, the court shall look into the same and try to ensure that the appeal is disposed of, preferably within 3 months.
Within a, my lord.
3 months.
Well, that would be
There's
safe.
nothing in, it will follow the suit.
Well, that would be earlier order passed with a single judge only.
Only
1
you
month.
know.
Sir, you have been most unreasonable.
Well,
What is 1 month in judicial proceedings says, eh? When you come and take adjournment, you take 8 weeks, 12 weeks over here.
my lord, this
And
is,
do you know the pressure that a trial court judge has to work under? Instead of coming over here, if you had gone, the single judge directed disposal of that MA within 3 months. If you had gone and pursued your remedy over there, it would have been disposed of by then. You have wasted 6 months to have this case posted over here.
my lord,
You are suffering simply because of your own attitude and not because of any other erroneous orders.
because, my lord, writ appeal was held in my favor. My lord, that is, nothing remains free for, my lord, this thing, my lord. That is the only endeavor I made, my lord. Please.
Number 10, Mr. Nayak NR.
I beg to appear for petitioner appellant, my lord. In this case, my lord, I have placed the order passed by this honorable court, my lord, writ petition and writ appeal. The order in question, my lord, already quashed and no more required to quash. Once again, the annexer B and C to be quashed. Now, relying on the one judgment has been passed by the coordinate bench, my lord, this writ petition is allowed. By quashing once again, my lord, beware, those orders already passed by this honorable court in writ appeal on 11/3/24, my lord. Therefore, I am before this honorable court, my, even though I have placed these orders already sustained. So therefore, need not be once again it is quashed because he has purchased site. Therefore, his site has been brought before the court, stating that these orders are passed by Assistant Commissioner and Deputy Commissioner, comes in his way. So therefore, he wants to quash both orders, my lord. In respect of particular site, it has been quashed the entire order, my lord, where the land was restored, which are sites only restored long back in the year 2016
Already the
itself.
order has been quashed, my lord. They are site purchase of site, my lord, basically. Already there is an order setting aside the.
So resumption of entire site purchase orders are.
Yes, my lord. The restoration is in respect of the entire extent of land.
Yes.
They are site purchasers of individual sites, my lord.
So how you are,
Order is there setting aside the.
how you are aggrieved, mister? Nothing to be aggrieved.
It's allowed relying upon order passed in previous writ petition, my lord, where both the impugned orders have been set aside.
Yes, we are dispensing heard learned advocate.
Land has been restored in 2014. Connected writ appeal, my lord, caused the notice, my lord. That is main order has been questioned in WA number 1492/2024, my lord.
What is saying?
Lord, he says that the order in WP number
1492
10360
bar.
of 22, my lord, which was referred in the impugned single judge's order, their appeal has been preferred, my lord. That is his submission. This order is passed relying upon that writ petition, order in writ petition. Writ appeal is pending.
Any stay is granted?
Writ appeal is pending, my lord.
Any stay is granted in the writ appeal?
No, my lord, because there is a delay.
So,
Therefore,
Lord
notice
learned
has been
advocate Mr.
cast.
So and so for the appellant who appeared through video conferencing and learned additional government.
Respondent number 1 and 2, my lord.
When the appeal is coming up, it might be lead to income. When the appeal is coming up,
1492, my lord.
1492 of
Bar 24, 2020.
This appeal may be listed with writ appeal number 1492 of
6th of March.
6th of March at 2:30.
Yes.
Looking to the compass of the controversy noticed today in course of the hearing of the present appeal.
This is number 11. The Misha Thomas.
Lordship, the order of the learned single judge at page 22 and 23, Your Lordship. At page 23, Your Lordship, we were directed to file affidavits, Your Lordship, under section 17B of the Industrial Disputes Act. Your Lordship, what had happened is the respondents, they filed their affidavits. We had filed our objections stating that most of them were already employed. 1 or 2, 3 of them had already retired. So the ones that were actually unemployed, we were to pay. Your Lordship, the learned single judge says, pursuant to the order dated 24, workmen have filed affidavit. Hence, management is required to comply the order dated 24 for payment of 17B wages.
So how many workmen are renewed?
Your Lordship, totally 22 of them. In that 22, Your Lordship, there are barely about 5 or 7 of them who are actually not employed. Rest of them are employed, and details, all of it, we have filed in our objection statement. Under 17B itself, Your Lordship, the provision states that it has to be proved to the satisfaction of the High Court or the Supreme Court that workmen who have been employed and have been receiving adequate compensation during any such period, court shall order no wages to be payable. Therefore, Your Lordship, the Honorable Single Judge should have gone into our objection statement and seen who all are employed, who were not employed, and directed us to pay. Instead, Your Lordship, Single Judge just said they filed their affidavits, so comply with 17B, only then you can proceed. Lordship.
Who filed it?
The respondent, the workmen, Your Lordship, that filed affidavit.
They have filed the affidavit that they are not gainfully employed.
Yes, and
That is the requirement of 17B.
Your Lordship, under 17B itself, the Honorable High Court could look into the aspect of whether they're actually employed or not based on the evidence and then direct it. Might I please, 17B.
It doesn't flow from there. High Court should look into it and inquire. Industrial dispute.
Idena. Industrial Disputes Act 17B.
54.
Where in any case, the Labour Court Tribunal, National Tribunal, by its award directs reinstatement of any workers and the employer prefers any
against such award in a high court or to the Supreme Court, employer shall be liable to pay such workmen during the period of pendency of proceedings in the high court or the Supreme Court full wages last drawn, inclusive any maintenance allowance admissible to him under any rule, if the workman has not been employed in any establishment during such period, and an affidavit by such workman has been filed to that effect in such court, provided that where it is proved to the satisfaction of the High Court or the Supreme Court that such workmen have been employed and have been receiving adequate remuneration during any such period thereof, court shall order no wages to be payable.
What is
All
it?
we are seeking is if the single judge could just look into our objections, nothing else, Your Lordship. Objections contains all the details of where they're already employed.
It is there to show that they are gainfully employed.
Please, Your Lordship. The PF details of
Okay.
what PF has been drawn. Yes, all of that we have provided, Your Lordship.
Produce.
So all we are seeking is if the single judge could just look into our objections and pass orders, nothing else, Your Lordship.
Where are, you have produced those details here?
We have produced that also, please. The second volume, Your Lordship. Page 635, Your Lordship.
So they are already engaged in
They're already employed.
elsewhere.
Please. So we have given a list who is already retired for quite a few years, who's passed away, and who have already been taken other employment.
PF account number. So this is some other, PA is what, which, some other employer.
Please.
Issue notice return. Notice returnable on 21st March.
Obliged.
Yes, number 12.
Pay for the accused. Orders are complied within the time granted. The matter was listed on 27/1/2025. On that date, my lords, your lordships had passed an order, my lords, directing that the order of the learned single judge be complied within a period of 10 days. My lords, now the order of appointment, my lords, is issued in favor of the complainant. My lords, before the learned single judge, my lords, the institute, my lords, did not argue. We have issued, my lords, an order of appointment in compliance of the order. And we have reserved our right, my lords, to seek for review of that order, my lords, as my lords, it was not argued before the learned single judge. May I place this on record, ma'am? Order.
The order of the learned single judge was in two parts. One is the appointment, second was the seniority to be fixed. At point number 6 in page number 4, it is stated, my lords, that the seniority will be fixed in accordance with the orders of the Honorable High Court. So both orders are complied, my lords. However, my lords, this new ground that they are pleading that we reserve right, my lords, they had represented before.
And number 3 and 4, my lords, are never appointed. Yeah, ma'am.
They had represented and argued their case before the learned single judge. Now, your lordships may kindly see the order of the learned single judge. It's 10th of August 2023. Now, the limitation period for review as well as appeal, my lords, has been, my lords, long gone. My lords, now in guise of this, my lords, they shouldn't come before the learned single judge or in appeal to say that since the liberty was granted by this honorable court, delay is covered there, my lords.
No. Delay, my lords, is to be considered, my lords, independently. I do concede, my lords, that we are not before the learned single judge, my lords, or before lordships, my lords, within the time stipulated. My lords, in the application that we would make, my lords, if at all we were to make out a ground, only then it will be considered, my lords. If not, this order will be confirmed.
My
Lords, now,
anxiety is only
the
that,
order,
my
my
lords.
lords, the order of the learned single judge, my lords, observation is made that, my lords, respondent number 3 and 4 to the writ petition, my lords, are appointed. My lords, they were in additional select list. They were never appointed.
Petitioner is now appointed or not?
Petitioner is now appointed, my lords. In terms of the order, my lords, it is appointed. She is appointed.
Where is that?
He is appointed.
Where is the order?
My lords, that order, my lords, your lordship may kindly see, my lords.
Translated copy at page number, which would be 3, my lords, of the memo.
Page.
Page
5.
3 of the translated copy.
Page 5. Page 5 and operative portion, page 7.
Yes, my lords.
The endorsement dated. Where is that? Date
7/2/2025.
7.
7th of February, 2025.
Where is that? 7th of
My
February.
lords, in the Kannada version, the date is available. Translation, it's not provided.
7th of February, 2025,
Yes, my lords, yes.
whereby the petitioner is apparently reinstated. Is
Appointed.
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 Is hereby rejected. For the simple reason that
No, it is not rejected.
My
my
lords,
lords. We have
we are
appointed.
rejecting this, Mr. Counsel. You can't improve upon the order of the High Court.
No, my lords.
You have improved upon by imposing condition. Can't pass such an order.
My lords, then,
Over
we'll-
is the withdraw, we are rejecting it right now. When we are calling your counsel, your client to be here personally to face
Lords,
the
may I
contempt
make this request?
and taking the High Court affront.
My lords, then I'll withdraw this condition what is imposed. And my
Withdraw,
lords, I'll
pass a
not,
fresh order. Pass a
Okay,
fresh
lords.
order is hereby rejected. At this stage, learned advocate for the respondent states that he will pass a fresh order of appointment.
my lords,
Compliance
the
with the
only
direction.
concern
No.
is, my lords,
You can't improve upon, you can't override, you can't overreach.
my lords, my lords,
No, you
Our
can't
only
put a
concern was,
condition.
my lords.
Whatever you do, want to do in accordance with law, you do it. You are at liberty.
Yes,
but
yes.
Not in the black and white.
Then, my lords, your lordship may kindly observe this, my lords, that if we are entertained in law, we are.
No, we are rejecting it right now. We are
Then
not
we'll issue a
countenancing such a conduct
simpliciter order.
on part of the contemptor who takes the court for a right.
We'll
Directly
pass
or
a
indirect.
simpliciter order, say,
No, sir.
no, we'll withdraw those conditions, pass
We
a
have
fresh order.
rejected. Where is the question of your withdrawing? We are rejecting
My lords, we'll
and
pass the
sounding
fresh
you
order.
a warning. If you are not going to pass a fresh order, you will
We'll-
hold up for contempt.
We'll pass a fresh order. We'll pass a fresh
We are
order.
recording that now. Pass learned advocate so-and-so at this stage, you will pass a fresh order.
My lords,
Such
no,
order shall-
institute, my lords, not government. Institute, my lords. Your lordship.
Whatever
said
it is,
government.
respondent, institute. That he will pass a fresh order appointing the petitioner in compliance with the directions which are under contempt. Full stop. Such order shall be passed and shall be produced on record on 21st of February at 2:30. Failing which, astern we will be taken by the court.
Public.
Come day after
Great.
tomorrow and produce the order.
We'll do it, my lords. Tomorrow itself. we'll do it.
Yes.
Great.
This is not the way to deal with the orders of the High Court.
My lords, only concern was that, my lords, that
No.
respondent number 3 and 4,
No,
my lords, were
not
not.
a single line we want to hear.
Yes, yes, we'll do it.
So 13 is urgent. Still number 14, to MC Basuraj.
Yes. So here, there is a delay,
Yes,
delay.
yes, there is a delay of 255 days.
Anybody appear? Notice returnable on 3rd April.
But notice is already ordered.
It is already, that is what we are asking. Anybody appears?
Delay.
Pass over.
Still number 15.
Yes, ma'am. Delay 197 days.
15 delay. Which delay?
Delay of 197 days. Who appears?
Maybe condone.
Condon. Chalo, appeal will be listed on 21st March.
Obliged.
Delay condon.
Number 16. Mr. Narsimaya K.
I am for opponent, your lordship. I have filed writ appeal.
Yes.
The order passed by the writ petition. So writ petition order is a oral order the single judge has passed the oral order in WP 6539, 2006, dated 31/7, oral order, and it is not a justified order. And also, two cases are pending in RSA, 16, 27, 26, and 27. Till this outcome, the appellant is in a position. I have submitted RTC 25 documents. Till today, I am in position, and sandalwood and many valuable trees are there. So, pray to study order of the WP. Because we are in position, this is a SC/ST land granted by the government and 15 years not to sell. So the respondent 4 had taken a will. Through that, he obtained the civil court order. Civil court order is not maintainable. The SC/ST order, the prohibition of grant of land. Documents.
So Learned Single Judge said that the mutations will remain subject to the outcome of the second appeal, in which the person applies claim regarding the gift deed will. And on the basis of that will, respondent 4 claims the mutation.
Mutation to an extent of 1 acre.
Civil litigation is pending. What is wrong in this order?
Kelstyle.
What is wrong in this order? What is wrong in this?
Writ petition order to be stayed because I am in position since 25 years.
Nobody is taking away your possession.
RTC have submitted document.
If you are in possession, that this order does not take away the possession.
What?
You are in.
I am position, Your Lordship. Till the disposal, the sandalwood and other trees are returned. And also, the granted land had to be made will during the period of pendency. The government SC/ST Act Gazette is there, Your Lordship. Not to taken will. Will in the court, civil court not maintainable. Violating the order, SC/ST Act, they passed the order. Still pending is there in RSA 1626 and 27.
Counsel, can you hear? Can you hear?
ಏನು ಕೇಳಿ
ಕೇಳಿಸ್ತಿದ್ಯಾ ಅಂತ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನಿಮ್ಗೆ ಕೋರ್ಟ್ ಹೇಳ್ತಾ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಅಂತ ಇದಾರೆ ಹೇಳ್ತಾ ಇರೋದು ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ನನಗೆ.
ನಾಟ್ ಏಬಲ್ ಟು ಹಿಯರ್.
You take somebody's assistance. Ask him to take some assistance so that he is. So we'll keep it on 4th March. Tell him the date. Sir. 4th March we are keeping you, or we will appoint somebody to assist.
4th March.
4th March date ಆಗಿದೆ ಯಾರು advocate ಜೊತೆಗೆ assistance ತಗೊಂಡಿದ್ರೆ ಅನ್ನೋದ್ರ ಕೋರ್ಟ್ ಇದೆ 4th March next date 4th March
4th March, sir. 4th March.
Still number 17. HV Devraj. 17. HV Devraj.
Awesome.
Number 18. Sumana Naganan.
Okay, for number 4.
Yeah, not the. Well then. Your notices were sent, RBI has been served now, Lord. The prayers in the writ petition, my Lord, this is against an interim order of the learned single judge. My main grievance, my Lord, is this, that the learned single judge has not considered any submission that was made before him before vacating the stay. Your Lordships will find the order, my Lord, at page number 31. An interim order had been granted on 28/11, which was vacated by this order, page 31. So, the senior counsel representing respondent 4 submitted that the petitioner's loan account, which was classified as fraudulent, has been declassified as not fraudulent subsequently. This court granted interim order on the ground that petitioner's loan account had been classified as fraudulent account without issuing notice. Therefore, interim order granted on 28/11/24 stands vacated. Now, my Lord, actually, this subsequently is incorrect because what had happened, my Lord, I need to give your Lordships a few dates, my Lord. The order withdrawing this fraud classification, I have myself filed in the writ petition. Just a few dates your Lordships may note now, my Lord. A complaint was issued by the 5th respondent, which was then the lender, my Lord. It was a bank, saying that the petitioner borrower had fraudulently borrowed money on the basis that some litigation proceedings which were pending were not disclosed. That was a case. That complaint, my Lord, was filed on 7th of June 2021. The police, my Lord, registered an investigation report case and filed a B report on 6/4/22, finding that no fraud was involved. Meanwhile, my Lord, the minute they filed this fraud complaint, they have to register this as a fraud case in the portal of RBI, which was done. Once a fraud complaint is registered in the portal, the regulations provide that no other lender can lend any monies to this entity. So it remained like that. From 22 onwards, no action was taken by the 5th respondent to report back to the Reserve Bank that the fraud classification has to be removed. In the meanwhile, my Lord, negotiation, this 5th respondent assigned its debt to 4th respondent, which is an asset reconstruction company. That happened in December of 22. So from April to December 22, they deliberately kept quiet, did not do anything. December 22 also, this newly acquired asset management company, R4, also did not do anything, kept quiet. We negotiated with them, and my Lord, an OTS was approved on 14/4/23. And as per that OTS, my Lord, I was supposed to pay money in 3 tranches. Your Lordships will see that at page 119. At 120, the payment tranches are there. First tranche, 11.85 crores.
Today, this order of learned single judge has taken effect.
Yes, the learned single judge has vacated the interim order. I am in appeal against that. My submission, my lord, is this. There are two submissions that I'm making. One, my lord, the institution of CIRP proceedings against me is a fraudulent act. They could not have filed a winding up dissolution proceeding against me. That is what I'm aggrieved by. I'm challenging that also. Because on one hand, they give me an OTS. I make two payments under the OTS. They don't remove the fraud classification. And then they withdraw the OTS. Now, my lord, another interesting facet is this. A sister concern of ours filed a writ petition before the learned single judge who directed that this fraud classification cannot be done without hearing, because Honorable Supreme Court has said, without notice and hearing, you cannot classify any account as fraud. The minute that notice came, they withdraw their fraud classifications as per annexures L and L1. That is, my lord, in October 24. Meanwhile, even before that, they go and file a CIRP proceeding. My submission, my lord, is that the institution of the CIRP proceedings and the IBC is a fraudulent act. I have the main prayers in the writ petition are that Reserve Bank should take action against them, that is this lender and the assignee, for violating Supreme Court order, for violating Reserve Bank regulations, and for not removing this classification. And to add insult to injury, when they remove the fraud classification as per annexure L, now the fifth respondent says, I am withdrawing the fraud classification.
So therefore, first prayer will not survive.
First prayer will not survive. First prayer, what survives, my lord, is that this declaration to classify is illegal, that will survive. The reason being, my lord, that the initial classification is only illegal, without notice.
That may survive.
Yeah. To the limited extent.
All incidental and peripheral assets may survive.
Yeah.
But now what is to be adjudicated in the respect of this interim order?
Yes, what is to be adjudicated are two things, my lord. First thing is the institution of this resolution insolvency process against me at a point of time when the fraud classification was there and they had not yet withdrawn it. That prevented me from paying the money. In fact, I have the money to be paid to them. I still have 80 crores rupees I can pay to them, but they don't want to receive it. They only want to twist my arm. My submission is not, I have raised, my lord, number of objections to the application for vacating stay. I have filed objections. None of them are considered. And the learned judge thinks that this withdraw. The interim order, my lord, had stayed NCLT proceedings pending.
So the grievances are two.
Yes.
One is considering your loan transaction as fraudulent.
Yes.
Second thing pertains to proceedings before NCLT.
Yes.
These are the two grievances you have got.
Yes, ma'am.
Now, with regard to your loan transaction being considered as fraudulent, it has been subsequently revoked.
Removed partially, I'll say, ma'am. Why I say partially is, they say that we didn't give you a hearing, so we're withdrawing it with liberty to continue the proceedings afresh. That liberty is sought to be reserved by respondent number 5.
That's a different aspect altogether.
I've challenged that also, my lord. I've said that this the reservation.
See, as of now,
yes,
it is not considered a fraudulent act.
Yes. Yes.
Tomorrow, if they want to do, you can always resist it.
Very well.
So, prayer A in the writ petition, main writ petition, prayer A, B, and C does not survive.
Not prayer A is to declare that classification as illegal now that they've withdrawn it. Prayer C, my lord.
B
will also.
Prayer B.
B also will not survive.
No, B is to take action. RBI to take action against respondents 4 and 5.
B cannot direct. B also.
There's a regulation which requires how they should do it. RBI is a regulatory body. They've issued directions.
No, your cause of action to seek prayer B doesn't survive assembly.
No, the fact that they issued.
It is classified as not fraudulent.
No, what I'm submitting, my lord, is this. For the time period of 21 till 24, this fraud classification was operating. That has seriously prejudiced me. So they can't get away, my lord.
That can't be gone into over here, sir.
My submission, my lord, is May I show your lordships RBI directives, my lord, as to how they should be
We'll
done?
look into it,
Yes.
sir. Then coming to prayer C.
Yes.
C also
Direct-
does not survive.
No. Direct respondents 4 and 5 to declassify my account.
It has already been declassified as not fraudulent.
So far as petitioner number 2 is concerned, they have not written anything to me. Petitioners 1 and 3. they have
We'll
written-
ask clarification from them. I think
Very
that
well.
will satisfy you with regard
Yes.
to prayer
If
C.
they declassify
Now-
that so far as petitioner 2
With
is
regard
concerned.
to admittedly, you are a debtor.
Yes.
Admittedly, you are a debtor.
Yes.
Now, with regard to OTS, you can't ask it as a matter of right.
Not as a matter of right. It was given. It was given and it was withdrawn at a point of time when this fraud classification was there.
It's contractual in nature.
Yes.
And respondent number 4 and 5 are not government companies,
No, but they are acting.
government banks.
They are acting, my lord, in terms of there are regulations governing this, how ARC should act. Asset reconstruction companies have to act in terms of Reserve Bank directives only. They can't do anything.
Now, factual disputes can we go into in writ
Not
petition?
factual, my lord. I'm only showing how fraudulently this has been done.
See,
Only a
it's-
few dates will make it clear.
Definitely, sir, they have to act in accordance with law.
Yeah.
It's your word against their word, whether they are acting in accordance with law or not.
My lord, in the letter, my lord, which they withdrew, they are saying it's illegally done. Kindly see the letter, my lord, which they issue.
We'll look into it, sir.
They
And then
say
the-
we have illegally done it.
And then the last one is pertaining to stay on NCLT proceedings.
Yes.
Now, if you are not repaid the debt, the creditor is at liberty to take you to NCLT.
But the submission I'm making, my lord, is that this filing of this NCLT petition on 11/1/10/24, even before the withdrawal of the fraud classification, is a fraudulent act. Is an act, my lord, in terrorem. My lord, on one hand, they give me an OTS. I pay part of the OTS amount. For the balance OTS amount, they keep this.
You can say the same thing before NCLT, sir.
No, but what I'm saying, my lord, is the institution.
First question doesn't hear in respect of the interim order which are you challenging.
No, my lord, the interim order, my lord, that I'm submitting, my lord, is this. The interim order, my lord, the learned judge has vacated it on the ground. He thinks that subsequently it was removed. It was not subsequent.
Interim order, it's up entire prayer of yours in the petition.
No, there are other prayers in the main prayer, my lord. Other prayers relating to Reserve Bank.
That is more valid before the NCL.
No, my lord, what I'm submitting is the other,
More valid, only valid before NCL.
my lord, Reserve Bank, my lord, has a certain statutory duty to perform. It has issued directives. It has issued guidelines as to how this should be done. If a bank, my lord, violates it, it may be private.
This appeal is focusing on the interim order only. nothing
Correct.
more.
What I am submitting, my lord, is that the manner in which the interim order was vacated, without considering any of these things, my lord, requires examination.
Sir, the reason assigned may not be very appropriate, but at the same time, the facts and circumstances of the case does not warrant an interim order. The interim order that you have sought for is stay of further proceedings in NCLT.
Yes.
Why should it be stayed?
I'll point out why, my lord. The submission I'm making as to why NCLT proceedings should be stored is twofold, my lord. During the pendency of an OTS settlement that was in operation, if the lender fraudulently classifies me as a fraud, does not remove that fraud classification, and allows me to default on that because there are letters, my lord, where we repeatedly plead to them to say, sir, you have classified as fraud, please remove the fraud classification. I have a lender waiting. The lender is waiting to pay the money. But because of this fraud classification, I'm not able to get that money is a submission we have
You
made.
sue them, sir.
No, suing them is one thing, my lord, but question is this, my lord, after all, my lord, CIRP is a proceeding in which, my lord, it is a death knell to the company. And in a case like this, my lord, if a lender behaves in this manner, conducts themselves in this manner, and then forces me to go to CIRP, my submission is, my lord, the court is not powerless to grant me relief. If an inquiry is held by the Reserve Bank against these two entities, and if it is found that they acted fraudulently, not only in not revoking the fraud classification, firstly, it's a false complaint. The police say this is a false complaint. And the police gave a report in April 22. 1 year later, my lord, we enter into OTS. And OTS, after that, my lord, after OTS, they should have withdrawn the fraud classification. They don't do that. They keep it. They know that I'm not able to repay the money because of that. Then they withdraw the fraud classification, the OTS. And before that could happen, they file a CIRP proceeding. And later, after filing the CIRP, they withdraw, saying I made a mistake in fraud classification. But this is nothing but downright harassment. No entity, my lord, can act in this fashion. I may be a borrower. I've told them, Lord, I've given them a copy of a demand draft for 40 crores to say, here is the money, I'm paying it to you.
Any scope for mediation?
I'm willing to pay them the money, 80 crores, I'm ready to pay. The balance 80 crores which I'm supposed to pay, I've got money and it's ready to pay now that this fraud classification is gone.
Respondent number 4. Any scope for mediation?
Instructions are no, my lord, because he's a repeated defaulter, chronic defaulter. Even on the OTS, it is not that it was revoked at our whims and fancies. He defaulted. That OTS was an attempt at mediation. We had taken a huge haircut at the time of OTS and had given huge concessions. Even on that, there have been defaults. Therefore, my lord, mediation is unlikely. In any event,
Lord, please see how
always
the
open
Supreme
to
Court
him to
views
make
this.
offers to us, and we'll consider. I think nothing prevents him from making any offer.
Please see what the Honorable Supreme Court says, my lord, in matters of classification of fraud. They're given directives as to how it is to be done. It's 2023, 6 SEC, page 1. They can't violate all law with impunity. Kindly go to the very last page of this judgment. Para number 98, the conclusions. The conclusions are summarized below. No opportunity of hearing being heard is required before an FIR is lodged and registered. Classification of an account as fraud not only results in reporting the crime to investigating agencies, but also has other penal and civil consequences against the borrowers. Debarring the borrower from accessing institutional finance under clause 8.12.1 of the Master Directions on Frauds results in serious civil consequences for the borrower. This is what I am submitting, my lord. Such a debarment under clause 8.12.1 of the Master Directions on Fraud is akin to blacklisting the borrower for being untrustworthy and unworthy of credit by banks. This court has consistently held that an opportunity of hearing ought to be provided before a person is blacklisted. The application of audio alteram partem cannot be impliedly excluded under the Master Directions on Fraud. In view of the time frame contemplated under the Master Directions on Fraud, as well as the nature of the procedure adopted, it is reasonably practicable for the lender bank to provide an opportunity of a hearing to the borrower before classifying their account as fraud. The principles of natural justice demand that borrowers must be served a notice, given an opportunity to explain the conclusions of the forensic audit report, and be allowed to represent by the banks and JLF before their account is classified as fraud under the Master Directions on Fraud. In addition, the decision classifying the borrower's account as fraudulent must be made by a reasoned order. None of this is complied. Since the Master Direction on Frauds do not expressly provide an opportunity of hearing to the borrowers before the classifying their account as fraud, audio alteram partem has to be read into the provisions of the directions to save them from the vice of arbitrariness. Then, my lord, the operative portion of the order. Now, my lord, if these dates are borne in mind, there was a concerted attempt, and this requires an inquiry, my lord. If supposing, my lord, the Reserve Bank conducts an inquiry, they will be bound to answer to them as to why from 6/4/22 onwards, before the OTS was signed, why did you not report back that this fraud is removed? Then, my lord, we give a the Reserve Bank has to, my lord, make a submission to your lordships as to what they're doing in a case.
Now, even your petition, nothing will survive, according to.
Pardon, my lord?
In your petition, nothing will survive.
No, what will survive, my lord, is two things that will survive, my lord. First thing is whether this respondents 4 and 5 can be permitted to go scot-free. That is a matter which only Reserve Bank can examine. Honorable Supreme Court has now issued
You
this
take your
direction.
you exert your remedies before any forum, any.
I've
court.
already issued and they have not done anything. Therefore, I'm before your lordships for mandamus. I issued them a representation to say all this has happened. Please inquire into the matter.
So that you pursue, we are not expressing.
No, it
any-
is in this case only, my lord, not a new case. The prayer.
Not in this proceeding, that's all.
No, my lord, in this proceeding, the main prayer is that a direction to Reserve Bank to conduct an inquiry against the conduct of respondents 4 and 5.
That in before learn a single judge.
That, my lord, if before the learned single judge, that prayer is there. I'm only saying that prayer is there. Then, my lord, so far as the events in which, my lord, I have now placed before lordships and the light of this, if in 22, I had to be removed as fraud, they don't remove me. 23, we reach an OTS. Again in November 23, because of this fraud classification, not able to pay the money. Then, my lord, they start OTS. They start the CRAP. And after starting CIRP, they go and remove the fraud classification. My lord, what does this mean, my lord? My submission is, my lord, that the proceeding, my lord, will have to be, my lord, stayed.
Who appears for Reserve Bank?
I appear for the RBI my lords, for respondent 1 to 3 my lords. We filed wakalat on 15th my lords. I need to take instructions from the RBI my lords.
Take it.
Till then, my lord, I request that let no precipitate action be taken by this before because what happens, my lord, is before the NCLT, if the proceeding goes forward and they admit the petition, then the board of directors will get superseded.
We are only wondering why the council is seeking time. Anyway, when? 6th of March.
Grateful.
Lord, I'm requesting for an interim order, my lord. There's an interim order granted by the learned judge, my lord. The only ground on which is vacated it, my lord, is this withdrawal.
To be very candid, we could have dismissed the appeal today itself, but.
Grateful.
Nineteen is attend, seal number 20. Mr. Ramatullah Kotwal.
They have not informed me from time to time unless
For the
they are taking
petitioner in this case.
adjournments. The fraud they have played by way of PL, it's purely a private interest. And the government 2-3 times, my lord, directed to secure those records. And we are the grantees, 1979.
Somebody wanted time on the ground of
Yes, sir.
illness.
Every time they are taking,
It is kept on 4th at 2:30.
please, my lord. Every time they are adopting same thing.
They are not taking your consent.
My lord?
They are not informing you.
No. Please, my lord.
Number 20, Mr. Ramatullah.
For the petitioner in this case, your lordship.
Respondent here. Here for respondent 20 to 65, for the directions of this honorable court, copy was served on the union only yesterday, Your Honor.
What is it about?
The encroachment of protected forest land, your lordship.
So let them be ready. We go to March 21st.
Please. Much of.
Number 21. Mr. Gauri Shankar S, party in person.
Gauri Shankar sir, party in person. I will explain my observations. I made a small summary for your convenience, my lord. I want to explain my issue, so I made small summary so that I can explain it better.
Yes.
Let's go to page number 2, my lords. So this is about how the property tax has to be paid. As per BBMP Act and BBMP property tax rules, the citizen, the property owner, should be able to pay the taxes through self-assessment forms. That is, there is no need for me to approach BBMP. It's my legal liability, so I should be able to pay the tax. However, BBMP has introduced a process wherein I have to apply to them, get a number called OTP, 10-digit number. Only with that number, I can go online and pay the tax amount. So there's no fixed process prescribed for this. So it's a very loose process. So BBMP has given a response. They have given a letter, annexure R1. So in that they have said an internal order will be issued directing the officers to strictly adhere to the timelines as specified and ensure that all applications are disposed of. However, that order is not issued. Because of the lack of this order or any proper governance around this, citizens are suffering in terms of paying the tax. And if they're not able to pay the tax, the penalty falls on them. They have to pay interest. So here what happens, because of the delays or faults of BBMP, the citizens are suffering. So I'm requesting a system wherein, as per the rules in the Act, there should be a provision for citizens to pay the tax online as per the self-assessment forms. This is my first request, my lord.
Yes, find out what is to be done. Find out to be listed on the who you are appearing for BBM.
For BBMP.
Please take instructions to be listed on 24th April. Next.
Bill number 22, so Usman P.
For the petitioner, 2 to 5, my lord, may I request? Kindly grant me a short accommodation, my lord, because I am not keeping well, my lord. The government had to.
Since Learned Council stated that he is not keeping will stand on 25th of April.
Bill number 23. The Ganpati Bhatt.
My lord, in this matter, the report is served today, my lord. We seek instruction and submit.
Find a joint survey report in this.
Yes, report.
Joint survey report has been placed before this court to identify a 2 acre of land was given for burial by the deputy commissioner, my lord. If your lordship look at the report, my lord, page number 11 may kindly be seen, my lord.
Yes.
The location of the burial ground is shown as serial number 516, my lord. Page number 11.
Map,
my lord. Serial number 5 and 6 are the burial ground, my lord. That is located in land marked as 1, my lord, serial number 1. That belongs to one Vinay Vitalkar, my lord. He is not the petitioner. The lands of petitioners are serial number 2, 3, and 4. That's adjoining land, my lord. So this is the reality position, my lord, insofar as the location of the burial ground is concerned. It is not exactly on the lands of the petitioners, but in the adjoining land, my lord. The order of the deputy commissioner has been subsequent, my lord. It is in 2020.
So which is petitioner's land?
Petitioner's land are marked as 2, 3, and 4, my lord. 2, 3, and 4 are the petitioner's land. Item number 1 belongs to one Vinay. The burial grounds comes within their vicinity, my lord, within that block 1. My lord, all that they are saying is that it is adjacent to their land and therefore they couldn't carry out the activity. That is their grievance. They have participated in the survey, my lord. They were present.
My lord, report is received today, my lord. Take an instruction and submit. 2 days time will be granted, my lord. Take instruction and.
No interim order is open. Yes.
In this case, my lord, report now they have given.
insofar as overlapping is concerned, they have clearly mentioned overlapping in our quarry list, which they have admitted by conducting survey. Either they have to, my lord, either they have to, my lord, cancel that burial ground has to be quashed, or they have to provide alternative quarry list to us.
They are not admitting overlapping.
Yes, my lord, that they have admitted.
Come to page number 11 of their objection statement.
Translated copies. Translated copies, they have not. Kindly see. Kindly see para 9 of that.
Come to page number 11.
Yes, my lord.
234 is your place.
Yes, my lord.
Yeah, the burial ground is in item number 1.
Yes, my lord.
That is 5 and 6.
A report may kindly be seen for a moment. The total area that is included in the spot merger. Spot merger in page number 9, my lord. Kindly page number 8, para 2. Further, in the ambit of said quarry lease, the Deputy Commissioner has ordered on 28/9/2020 at 4/11/2020 respectively reserving 2 acres of land, each for the purpose of construction of solid liquid waste disposal unit by Gram Panchayat for general public and burial ground for general public. During the joint inspection, it is found that the burial ground is reserved for the general public and the restroom building have been identified inside the quarry leased area 803, and the road leading to the solid liquid waste disposal unit of Gram Panchayat also passes through the area of quarry lease 809 and 810. There should not be a public structure.
You are not 803.
8, kindly see. I'll file this since just now I have received, but kindly see quarry lease. Quarry lease is, my lord, 128 20 guntas, 128 30 guntas, 128. Quarry lease, my lord, is, my lord.
You are 710.
There are 3 quarry leases. 3 quarry leases. 3 quarry leases which we have produced before this court is, my lord, at page, your lordship would find at page, my lord, 51. 710 first quarry lease. Then, my lord, second quarry lease is 810 in page number 78, annexure D. 810, my lord. Third quarry lease, which is third petitioner's, my lord, is owner of quarry lease number. Your lordship would get 809 at annexure E in page number 1.
That's it. You are not 803.
809 and, my lord, 810. Kindly see in the quarry leased area, if they are permitting to activities because there should not be a public
The
structure.
writ petition pertains to
3 quarries.
No, the writ petition pertains to only burial ground.
But yes, my lord, that we have stated that if it is burial ground is quashed, we have no objection. That is overlapping with our quarry lease, and 200 meters from our quarry lease, there should not be a public structure.
Sir, burial ground is not within your area of quarry lease. Burial ground is outside. You just now read it. It's in 803. It is not in 710, 810 or 809.
809. Here,
okay,
therefore,
only the road passes in your quarry lease, and it's not a patta land. It's a government land. So nothing wrong in the road passing in your quarry area.
I'll find just, my lord, that I have received and I'll have it tomorrow. I'll clarify that. I'll clarify this. Since, my lord, even translated copy also has not been served. Have it tomorrow, I'll clarify. Since, my lord, as per, my lord, conditions of KMMRC rules, even road should not, public road should not be there as per terms. Therefore, what my request is, either they have to cancel burial ground or, my lord, to allot alternative land, that is 800 acres are there. If at all, if they are undertaking before this court,
Or cancel your mining lease.
that is, my lord, I have invested huge amount, and, my lord, what is my bread and butter? Therefore, my lord, it is 20 guntas, 1 acre. Therefore, my respectful submission, if they let them take instruction, because road, public will not conduct quarry activities if it is road is formed. Under those, let him take instruction from Deputy Commissioner as to whether they can grant alternative same land. I'll make, my lord, submissions tomorrow or day after. 5th March, please. I'm sorry, it's a little bit late, my lord, sir. I'm attending.
24, Somshekhar KH.
Yeah, for the respondent number, lots 4. Lots, there is a suppression of Milord's facts. For the reason, Milords, that the same petitioner, Milords, is a respondent number 5 in a writ petition filed, Milords, by the respondent number 4 hearing. And there is a stay, Milords, of the very same government order. And, Milords, he files wakalat and thereafter files objections. Now, Milords, concealing that particular fact, Milords, of pending writ petition, where, Milords, this order is a government order, 29/9/2022 order, Milords, which is stay, and where he files objections. And thereafter, Milords, he files the present PAL, seeking, Milords, implementation and enforcement of the same government. It is stayed. It is stayed, Milords. Milords, kindly, Milords, I'll be placing it on record, Milords. I just pass on. Milords, respondent number 4, Milords, files writ petition on 27/2/2023.
Same petitioner is there.
Yes, Milords, same petitioner is there, respondent number 5.
I don't know this. You don't know, we know now it is part of the.
Well, now it's, when there is a stay, this writ petition will have to be.
Pardon?
I'll ask him to withdraw the writ petition, when there is a
You
stay.
can't have 2 horses to ride.
Yes.
And that too, subsequently it is filed public interest petition.
Yes, Milords. Kindly see, Milords, 29/5/2023, he files wakalat in the other writ petition. He files, Milords, statement of objections on 23/6/2023. Then, Milords, the present writ petition is filed, Milords, on 25/10/2023, much after, Milords, filing objection.
Statement of objection is filed by them.
Yes, Milords, filed by them.
Where?
Milords, that is on 23/6/2023 in the writ petition.
The writ petition by the same petitioner, Rajanna.
Milords, writ petition, Milords, is filed by respondent number 4 hearing.
Respondent for, sorry, Indian Gymkhana.
Indian Gymkhana. Now he is seeking implementation of the very same government order.
He is there.
He is there, Milords, respondent number 5. He files wakalat and thereafter files objection. Then, Milords, suppressing that particular fact, Milords, he files the present writ petition.
Wakalatna was filed there.
Yes, Milords, filed. Statement of objections is filed.
Wakalatna was filed when?
Milords, that is on 29/5/2023. 23/6/2023, Milords, is the statement of objections filed.
This petition is filed when?
This petition, Milords, is filed on 25/10/2023.
6/10.
6/10.
Yes.
So after statement of objections.
Yes, Milords.
And about this proceeding is not stated.
No, Milords.
So we impose cost. Expense with the cost of 35,000. Really is suppression and misleading. Yes, we'll pass.
After interim order, you filed writ petition. Please.
May I just pass on, Milords, the decision of the Honorable Supreme Court, Milords, on the suppression of facts, considering the earlier
The interim order.
Number 25, Mr. Srinivas Kane.
Yes, my lord, I am for the petitioner. The petitioner is running oil mill, my lord, in the petition schedule premises for the last several years. And the second petitioner is also growing sugarcane from the last more than several years, my lord. The earlier, the state government, my lord, had issued notice, my lord, for action of this land, my lord, of which it is challenged before this court. Kindly turn to page 55, my lord. Annexure G. This court granted an interim order, my lord. Let the 56 at page Annexure G, second order. Issue emergent notice, learned additional government is requested to accept notice for 1 and 2. The scheduled action shall go on short of issuing confirmation order from the till the next date of hearing. Let immediately, my lord, order, this order has been notified, gazette notification was published by the state government. Kindly turn to page 57, my lord. Annexure H at page 58, my lord. It is mentioned, as per the Karnataka High Court order, in the matter petition number 9882/23, dated 4th May 2023, the scheduled action process for NIT dated so and so shall be subject to the outcome of the order in the said petition. My lord, again, my lord, immediately after, within 1 month, my lord, on 15/5, my lord, after having this order, my lord, kindly turn to Annexure J, my lord, at 59. They annulled the action, my lord, and issued a notification on 18/3, my lord, 23. The entire action was cancelled. Subsequently, my lord, within a period of 3 months, they issued fresh notification, madam, which is at Annexure K, my lord. K, page 60, translated copy at 61, covering the entire area. Again, same land they have issued, same without deleting the lands of the petitioner, my lord. And even the earlier order passed by this court was not mentioned in the notification, this present notification, my lord. And the petitioners, my lord, that is they are living for their livelihood from the last several years, my lord. And Supreme Court repeatedly says, my lord, no private properties can be granted or leased out. This is the one of the judgment. Without taking the consent from the petitioners, my lord, the notification has been issued. That has to go, my lord. And they have to, by deleting our lands, my lord, they can do anything.
Lord, the first notification, my lord, was annual, my lord. That was issued on 18/3/2023. Page number 59, my lord, that came to be annulled, my lord. This honorable court in the writ petition has permitted us to proceed, but short of confirming it. Thereafter, the writ petition was disposed as infructuous, my lord. So it was subsequently annulled also. Now, the second notification, my lord, is at page number 61. That was issued on 9th October 2023 with a date fixed as 10th November 2023. This honorable court granted an interim order here. And again, this we couldn't proceed with, my lord. The second notification also we have not, we have to do it afresh, my lord, end of the day. We have to do it afresh because this second notification was 9th October 2023. Fixing the date of auction as 10th November 23. This honorable court passed an interim order. Therefore, we have not proceeded with this auction also as on today. So therefore, that is one part of the prayer, my lord. Now, all that they claim is that they have an oil mill running within this premises. Nothing has been placed to show that to that extent, my lord. We have to re-notify now.
No, I have placed.
No, the
all the
question
materials.
is, the land is government land or private land?
This is a
His
Pata land.
contention is it is a private land.
Private land.
Pata land he has purchased subsequent, my lord. Originally,
Then there is no question of putting it in auction.
Yes.
no, my lord, originally it was 1968. There was an auction given to Mysore Minerals, my lord, for a period of 50 years. That
See, that is
expired.
different. Right now, who owns that land?
Land belongs to them, my lord, but there is limestone that has been requiring.
Fine, how can you put it on an auction?
Lord, otherwise
It's a private land.
my lord, it can't be used for any other purpose. End of the day. Earlier also it was.
That's a
private
different
land.
thing. You acquire his land, he has got ownership over the property concerned.
Earlier also it was a government land. As per the scheme, my lord, he will be entitled for compensation for the.
Council, for that you have to acquire his land in the manner known to law. Just because you strike some mineral on a private land, you cannot put it for auction.
Permissible under the statute.
Show it.
That is, I'll seek a short accommodation. I'll place the relevant provision, my lord, because this is the land which is given on auction, my lord. Under the mining auction rules, my lord, they are entitled for compensation for
Great
usage
thinking.
of the surface minerals.
Better take proper instruction.
Please, my lord, I'll place the relevant provision.
11th March.
Number 26. Fairness, but
Somebody wanted time. You wanted time? Wanted time?
No, in this case, whether I have not mentioned that. In this case, in spite of a 321 confirmation and 462 KMC demolition order, the urban authority is not taken any action. I have given several representations. Again, their illegal structure has been continued even today. In spite of 462 order authorizing particular person for the auction and the cost of respond number 6.
Yes, what is your story?
Mellas, I am appearing for respondent number 9. I am a private citizen who owns the property which was originally allotted to my vendors by the government. And there is no notification against my name. I pray my lords 2 weeks accommodation. I will place my documents on record.
28. As requested.
number 27. Sure. Neeralgi?
Yeah, for petition.
Challenge before my lords is the government order empowering the Waqf board to my lord issue a marriage certificates. Without the authority of law and my lord, the goes contrary to the provisions of the act.
Yes, proceed.
My lords.
Can I submit my lord's time?
My lord, I need some time in this for the simple reason, my lord, there is a technical defect. This order has been issued without a notification being issued by the government, my lord. So I need to take instructions with regard to that. Government orders are issued without the notification.
They have power to issue the government order. May I just clarify, my lord?
You are for?
My lord, may I?
You are for whom?
My lord, I appear for the Waqf board, my lord. I seek permission for my lords to just say. Lord, in fact, I'm thankful for the petitioner for having brought this petition, because now there is no law, as we understand, to register a Muslim marriage conventionally. Now, the two enactments which provides for registrations are Special Marriages Act and Hindu Marriage Act. Hindu Marriage Act is specifically only for Hindus. Special Marriage Act is a marriage between inter-religion and not between two Hindus, because the marriage takes place under the Special Marriages. Now, there is another act, my lord, which is called as the Karnataka Marriage Registration Miscellaneous Provisions Act, which empowers the government to appoint as many registrars to register a marriage under this act. Now, the mistake that is happening is the Waqf board is registering as if under the board. They don't have. They should have registered it under this. And the government order is directly issued to do this. So let them get instruction. Lord. Power is there for them. It's not that there is no power. Now, Lord, to add one more thing. Now, the sub-registrar of stamps under the Karnataka Stamp Act is the authorizing authority. Now, if we look at and extend this argument of my petitioner, under the Stamp Act also, the sub-registrar has no power to perform a marriage. But he is performing. But he is performing in another act. So like that, a Waqf officer who is a government employee in the sense, who is an employee of the board, who is governed by the civil services rules, he is empowered under a different act to perform this job. Lord, all this, Lord, we will file detailedly. My lords would consider, my lord, then find a way out. We are not, Lord, for a moment, kindly take my submission that we are not saying the board should do it under the board. No. My lords have correctly, my lord, written there that board has no power to perform marriage or give anything. Under miscellaneous powers, with conjoined to another act, the government authorizes such an officer to perform that power.
So file your counter.
Yes, my lord.
Right.
Additional counter.
Waqf board has filed a counter.
I'll file an additional counter. Additional counter, your lordship may
Lord,
permit
only
me.
that one
And let them
point,
also
my lord.
file, they haven't filed their statement of objection. We are not, my lord, saying board only should be given. Any authority, my lords, may give. Our only interest is to see that a Muslim marriage that has happened conventionally under the personal law is given some sanctity. That's all. For which no law is there at this moment.
While learned additional government advocate Nilofer Akbar prays for time, while granting time till 19th March, it is provided and directed that if the parties want to complete the pleadings, the same shall be done before the next date, full stop. The presented petition paragraph is directed to be put up on board for preemptory hearing, looking to the importance and the dimensions of the subject matter.
We'll assist the court.
Obliged.
So no time will be granted.
Yes.
Don't write that.
Yes,
Don't write that. No time will be.
Seal number 28.
I represent, Lord, in the three matters, 28, 29 and 30. Lord, in 29 and 30, Lord, the petitions are infructuous. I am filing memo, Lord. 29 and 30.
All right, 29.
And 30.
Nagaraj
I'm filing
files a memo.
They are infructuous.
Dated so and so
Whereas,
stating that the
29 and 30.
infructuous.
But 28, Lord, I am filing memo for withdrawing the petition.
The memo is taken on record, the petition is disposed of from in view of memo as having become infructuous. The same order in 29.
28, Lord, I am
Sorry,
filing memo for withdrawal.
29 and 30 disinfructuous. And 28,
28, Lord, I am filing memo for withdrawal.
same memo is. filed.
Liberty, Lord, with if need arises.
Nagaraj ji, wherein it is stated that the petitioner wants to withdraw the petition, memo is taken on record. In view of the memo dismissed as
No,
withdrawn.
liberty, Lord, if need arises.
No, liberty is always there.
Please. Please.
Number 31, Mr. R.B. Sadashivappa.
The petitioner, my lord. Yes, the petitioner is a constructions company, my lord, who has obtained the plan for construction purpose. Wide annexure D, the respondent number 2 is a geological department have issued a notice
My lord, I'll take notice for respondent number 2, and my lord may grant me some time, my lord, I'll file my statement.
Notice written ever. 29. Learned additional government. National for accept notice. Yeah, respondent state. Notice is already issued.
My lord, served and unrepresented, my lord. Served and unrepresented. R2.
10 to 29. Next.
Lord, date, my lord.
29 February.
Apply.
Number 32.
Here for the petitioner, your lordship.
My lord, I'm producing the government circulars, my lord, wherein we have complied.
This is 32. 32.
Lord, with the directions, sir.
Court office.
Sorry. What is it about?
Copy.
So they are acted upon, complained. The directions in the common cause. What are the directions?
My lord, for the appointment of competent officers of the local governments, my lord, we have the director, my lord, as per the government order dated 30th January 2025. My lord gets it at page 2. The
14
principal,
to 25, not even.
yes.
Yes.
So they have appointed, lordship, find this at page 6. They have appointed the executive officers of the concerned taluk panchayat to rural areas as the competent authority. And then
The competent officer is appointed by which? Where is that?
government notification dated 14/2/2025 at page 5, your lordship. Through that, they have appointed at the taluk level an executive officer as the competent authority. And at district level, at page 7, your lordships will find they have appointed the zonal commissioners of the concerned zone of BBMP as the competent authority, and they're saying that zonal commissioner, which is given in the Supreme Court judgment, may be read as joint commissioners of all zone as the competent authority.
That we have done by way of a corrigendum, page 7.
That's what I was reading. So I'm not able to see through the circulars if there is anything which says that the competent authority can, where there's a direction given that they can actually collect all the living wills.
Where is corrigendum? Ah, yes.
There is a direction also given where they can collect all the advanced medical directives that will satisfy the PIL that we will find.
My lord, if I could just have an interaction with the concerned officer, my lord, 2 minutes. My lord, page 6, internal page 2 of the notification dated 14/2/2025. My lord, instead of narrating the whole thing, my lord, we have said in accordance with the directions at paragraph 198.3.1 of the said orders of the Supreme Court.
Kindly requested that there's an order passed by the municipal court saying that the competent authority to collect as directed by because the paragraph that they're reading out is the paragraph which the guidelines say that a competent authority should be appointed. If through the order of this honorable court, if there is a direction given to the competent authorities to collect all the living wills, that should also suffice, your lordship. Because the
My lord,
intent is
let's
there.
keep it by way of a memo, my lord, I'll reply to that.
No, the intent is there, but if it just,
Give a memo. We will dispose it. You, whatever you want to say, say.
Yes, yes. I will
Monday, your
clarify
lordship.
it.
Monday.
Not Monday, no.
No, there are several senior citizens who are waiting to deposit.
10th of March.
My lord, 10th of
Great.
March, my lord.
Great.
Number 33, the J.R. Mohan.
It respond, Your Worship. Press week's time to file a statement of objection to the petition, Your Worship. Press week's time to file objection, Your Worship. Statement of objection. Yes.
My lord, this pertains to illegal construction that is put up by respondents 7 and 8 on a Raja Kaluwe, my lord.
One submission.
Respondent who else
Lordship.
wants to file statement of objections to enroll to 25th April.
That one submission, man. This case is filed in interest of the public. The land belongs to the government on the Raju Way. Well, the 7th and 8th respondent, my lord, construct a building for commercial building. They let the rent to various persons after filing the case. And there is a direction of the honorable court. Even though they have finished the building, they are given a rent out to the various persons. Now they will suffer if the court passes an adverse order against them. The tenants will suffer. They are investing crores of rupees for their business. And now this case was filed in the 2024. And after passing the order, the BBMP till today they are not taken any action. They are all colluding with the respondent number 7 and 8. If the officers are doing like this, what is the use of filing the petition, my lord? Intentionally, they are kept quiet from last 8 months. At least, my lord, they have conducted the survey, they are issued the notice, what they have taken, even today, the BBMP is not taken any action. Lord, it's a crores of rupees of property belongs to the government. The respondent 7 and 8 put up the construction. Lord, at the time of filing the construction, it was some 50% was completed. After that, my lord, after filing the case, day and night, they are constructing the building and they are given a rent to various shops to the various persons. Well, at least, BBMP let them take action against the respondent 7 and 8. Till today, they are keep quiet. My humble request is, till then, the respondent 7 and 8 not to let out any shops to any third parties or not to put up further construction. At least the lordship kindly pass an order in this regard. Otherwise, they will complete the building. Now, 4th or 5th floor is now constructing. Till then, next date or filing the written statement. Then suppose, if they let out the rent to the various persons and the tenant will suffer because they are investing, they have taken the loan and they borrow the money from the public, from the land money lenders. They are investing, suppose, if the court pass an order for demolition, they will suffer. They will suffer. That's why, my humble request is not to put up any further construction and not to let out any premises to any third parties to the rent till next date of hearing or whatever this court may pass an order. Otherwise, the parties will suffer.
Sir, 34 is urgent, number 35.
Yeah, what is the next?
25th of April.
February, this month.
April.
Number 35. Srimati.
Lordship, at least the interim order may be. Otherwise, the parties will suffer, my lord.
In the interest of public, I am requesting honorable court.
Interim order is refused.
Lord, I have no objection to the early hearing application. In fact, I've filed my written submissions already.
But the reason why we have filed this early hearing application is, but this public interest litigation is 10 years old, and they are seeking to challenge a lease cum sale executed in my favor, executed in the year 1985, on the ground that the lease cum sale, not the area, should now be earmarked for park.
PIL.
Yes.
Oh.
10 years, not 1985 is the lease cum sale in my favor by the BDA. PIL is filed to seek quashment of that lease cum sale not executed in the year 1985. The only ground, the mandamus they are seeking is, it is now earmarked for industrial purposes. It should be changed to park purposes. But I must bring to Lordship's notice, earlier, in fact, BDA rejected this. But we approached this honorable court, and there is a direction by this honorable court to execute the sale deed pursuant to which.
With due respect, my lord, the sale deed that was
Your
executed.
industry has come up.
No, Lord, it is presently vacant. The reason is, Lord, because of this litigation. Lord, we have not been able to put up anything.
The sale deed was executed only in the year 2014, my lord. And there is a catena of litigation that went on before that, where there are various false representations that were made by the third respondent before this honorable court in other litigation, stating that I will only use it for residential purposes, etc. I'm ready to go on with the matter, my lord.
But I do not want to interrupt my learned friend. But just one, my lord, decision, my lord, one observation of this honorable court, my lord, I may just point out. Kindly see, my lord, page 89, division bench order, where they refused lease sale deed execution only on this ground at page 89. Page 89. This was BDA rejected, my lords, our request for execution of sale deed on the ground that it comes in a residential area. The appeal is allowed in part. Order passed by the learned single judge quashing the endorsement is confirmed. There is a direction issued to execute the sale deed. Then, my lord, the BDA once again took up this and said that sale deed cannot be executed. That, my lord, lordships will get it at page 345. This is the endorsement issued by the BDA at page 345. Last paragraph, lordships may kindly see the endorsement of the commissioner. Lordships, 345. May I read last? Therefore, keeping in mind the above mentioned facts and circumstances, I am of the clear opinion that the request made by Sri so-and-so to permit him to retain the site number 5A Koramangala does not merit any consideration. The site in question can under no circumstances be allowed to be put to use for industrial purpose, which goes against the CDP norms and the layout plan earmarks as approved by the government and the authority respectively. The allottee should be content with the alternative package and that has been offered in the form of an industrial site in the industrial suburb. This was called into question in writ petition number 37-496 of 2009, which is the next order. In 2012, my lords, this endorsement was quashed by this honorable court, imposing costs on BDA at page 361. I'm sorry.
341.
I'm sorry. I'm sorry, I must have a little bit.
The paging.
I'm so sorry. 345. I'm sorry. My apologies, my lords. I was a little too quick. 345 is correct.
345.
345.
So what is the 345?
345 is an endorsement issued by the BDA, Lord, affirming the same prayer which is made today before your lordship, saying that we cannot permit industrial use. Page 345, last paragraph. This is the endorsement issued by the BDA commissioner, page 345, last paragraph. But I'll read it again.
Here.
Therefore, keeping in mind the above mentioned facts and circumstances, I am of the clear opinion that the request made by Sri so-and-so
Sundar Murthy, my lord, was my predecessor.
Hmm.
To permit him to retain site number so and so Koramangala does not merit any consideration. The site in question can under no circumstances be allowed to be put to use for industrial purpose, which goes against CDP norms and the layout plan earmarkings as approved by the government and the authority respectively. The allotee should be content with the alternative package that has been offered in the form of an industrial site in industrial suburb. This was the endorsement against us, which was called into question in writ petition 37-496 of 2009, which is the next page, which is at 347. This endorsement was elaborately considered by the learned single judge and held that the CDP now shows it as an industrial land. The question of rejecting does not arise.
Page.
Lord, the relevant portion, Lords, would be
Petition is allowed.
petition is allowed imposing costs of 20,000 rupees. Thereafter, now again, my lord, this public interest litigation is filed on the same ground. Kindly see the prayer in the writ. I'll only point out the prayer in the writ petition.
My lord, I'm not being permitted to
40,
make my
I'm
submission
sorry.
unless I present
Yes.
my case.
No, I only wanted to preliminarily point out our objection, not to interrupt my learned friend. No?
Now, as far as your prayer not to use for industrial purpose and to you put to use as park.
Yes.
Appears to have been negatived by this court.
No, my lord, with due respect, I'll take my lords through the submissions. What had happened was in 1979, the site that is vacant site 5A, which is subject matter before this honorable court, there was a layout that was formed in 1974, and in 1984, this particular site was earmarked as civic community site. I have produced several documentation to show that this area is a civic community site. It is settled law.
Are we in appeal over this 340?
No, my lord, we are not in appeal over that. I was not a party to that. This is a public interest litigation that has been filed. And particularly that the BDA, what has happened is the BDA's director has sold the site to his son. And that son has then sold it to a developer on the same day for 18 crores. What is a park site? That is why the residents are before this honorable court saying that a civic community site cannot be alienated in violation of the Karnataka Town and Country Planning Act, in violation of the applicable provisions of the Bangalore Development Authority Act, which is why, my lord, I'll take my lords through that. If my lords kindly look at my written arguments that I have filed on 7/10/2023.
B723.
7/10/2023, my lord. If I can take my lords to Annexure A series at 17 of my petition, which clearly describes that this scheduled property is described as park. If I could take my lords to page 27 of Annexure A, my lord, Annexure A series. No, sir, I've already. Could I trouble my lords to kindly take my petition, my lord? Where Annexure A series at Annexure A1, page 20.
Page 20.
Page 20, my lord. This is the sale deed offer adjacent site, adjacent to the scheduled property before this honorable court. My lords have it, page 2020. Yes, my lord, schedule. Industrial site number 3H. Kindly note the scheduled properties, site 5A. This is 3H, formed by the first party in Koramangala Industrial Layout, site bounded on the east by park. This boundary park is site number 5. And then if I could take my lords to the next sale deed, the typed copy is at page 27, my lord. My lords have it. where again there is site number 3J, my lord. East, again, the boundary is park. So what is the site? This site 5A that has been sold to the private respondent herein is a public park that was earmarked in an industrial area, both in the CDP, in the ODP, which is the Outer Development Plan in the year 1972, in the CDP in 1984. And this, the nature of the park has not been changed since. And my lords are well aware that for change in land use under section 14A, an order has to be passed saying that this area is no longer a park. It can be used for other private purposes. That has not been done, admittedly. Then whatever the learned senior has said with respect to that multiple litigations that was there, it was by the BDA director who got the site allotted to his son by way of a lease cum sale agreement that was executed in 1985, my lord. Subsequently, after the entire litigation in 2014, they obtained a particular order which we are not aware of. We are at the end of the day public spirited citizens. We live in and around there. And what is our intention? Only to save the green space, my lord. This is the only park that is there for residents. And we've in fact made several representations to all the authorities, including the local MLA and the MP, stating that please retain this as park. When is this park? Ensure that it does not change hands. I'll take my lords through all of that, my lord. Now, this sale deed is executed only in 2014. Before I take my lords to the sale deed, it may be noted that the sale deed is executed for a paltry sum of some 2 lakhs, my lord, by the BDA to the private respondent. Private respondent then sells it for 18 crores that very day to the 4th respondent herein. That itself shows that this is nothing but an attempt to usurp public land for an exorbitant amount.
That is true.
Yes, my lord. My lord, if I could take my lords to the respondent's affidavit, the first respondent, BDA's affidavit, to see what their stance is. If I could take my lord to, this is filed on 15/11/2021, my lord.
Page 267.
325 is the document I'm looking at, filed on 15/11/2021, my lord. My lords have the objections, my lord. It's styled as an affidavit filed by the first respondent. Filed by one Mr. Rajesh Gowda, my lord, who was the commissioner of the BDA. My lords have it. At paragraph 3, if I could take my lords, page 268. My lords have it.
Yes.
In the bottom, from the bottom, my lord, bottom of paragraph 3, where it says in the Comprehensive Development Plan 1984. In the Comprehensive Development Plan 1984 and in the Revised Comprehensive Development Plan 1995, the area was shown as residential zone. Copies of the relevant portion of the said CDP 1984 and RCDP 1995 as produced as documents number so-and-so. In the revised master plan, the area of the site in question is shown in industrial high-tech. Then, my lord, at paragraph 4, on the request, on page 3, on the 3rd line, my lord, on the request of the 3rd respondent, the then chairman BDA, without considering the then prevailing BDA allotment of site rules 1984, passed order dated so-and-so. This is the 1985 lease cum sale agreement allotment for allotment of the site in question, and as per the order of the then chairman BDA dated 12/3/1985, first respondent allotted site number 5A, etc. So they themselves admit that the allotment that was made in 1985 in favor of the 3rd respondent itself is improper, and it was against the prevailing rules there. Then, my lord, At paragraph 7, if I could take my lords, paragraph 7, page 5, which is running page 271, my lord. My lords have it, paragraph 7, my lord. I submit that pursuant to the order passed in so and so, objections of the third respondent has been considered since in the CDP 1995. I request this honorable court to take note of that. Since in the CDP 1995, area in question was shown as residential zone, and in the boundaries of the adjacent sites, the area in question was shown as park. BBMP is requested to retain the area as park. The first respondent authority in its authority meeting held on so and so resolved to allot an alternative site to the third respondent. All along, the BDA says that this is in fact a park. This is the BDA's affidavit itself. And in fact, they set out the entire litigation, my lord. I'll not trouble my lords through that, where the third respondent repeatedly came back to the court on one false ground or the other, refusing to accept the alternative ground and instead insisting on this parkland that was reserved for public purpose. Then if I could trouble my lords to go to page 325, my lord. This is their document, document number 25. My lords have it. This is one of the many writ petition orders, my lord. At 325, at 327, if I could take my lords. Where unnumbered second paragraph, my lord, on that page, in the statement of objection, it is stated that the allotment of site in favor of the petitioner is for an industrial purpose, whereas it comes in a residential area where 11 residential sites have been formed. In view of the averments made by the BD and the statement of objection, my lord, this is at 327, my lord. In view of the averments made by the BDA and the statement of objections that the site in question is earmarked for residential purpose in the CDP, I called upon the petitioner to make a statement before this court that the said site will be utilized for residential purpose. In reply to this, the learned counsel appearing for the petitioner on instructions submitted that the site in question would be used only for residential purpose. In view of this statement, no harm will be caused to the BDA to execute the sale deed in favor of the petitioner, as it has already collected the consideration from the petitioner after the allotment of site. Now, under this circumstance, my lord, the sale deed has come to be executed. And this is in 2003. Subsequently, litigation goes on. In 2014, there is a sale deed that is executed. If I could take my lords to the CDP itself. Annexure B, my lord. Page 28, it's a large map, my lord.
Of your petition.
Yes. Annexure B. Immediately after Annexure A, where I'd refer to the sale deeds, my lord, page 28. I'll point out. B for Bangalore. Yes, my lords have. My lord, here the right of the plan, my lords will find a dense thing, purple and brown, and there's a thin sliver of green sandwiched between purple and yellow. My lords have it. On the right, it says district number 17. May be permitted to point it out, my lord.
On the right side.
Yes, ma'am, deeply obliged. On the right, just before the legend of the map, before the index, just prior to the index, my lords will find these letters, district number 17. My lords have it. There, my lords will see a lot of yellow, and there's one thin sliver of green. That is the site in question, my lord.
Which area is industry?
My lord?
It is in the.
Yes, my lord, it is in the industry. In fact, the sale deeds that I pointed out to my lords also, the plots that were there, the entire area was industrial thing, but they made residential sites in the industrial area. Can you at 2:30, my lord?
One appeal is going on. At 2:30 it is kept.
Yes. Whatever is convenient, whatever is convenient.
It can go after 10 days also.
10.
After, in the week of 17th of March.
Some date lots, whatever is convenient. I'm told lordships have already had given the date as 4th March earlier. Is at that point of time we had filed. Yes.
4th March.
Yes.
4th.
4th.
Lord,
2:30. Not if it is convenient, it's at 2:30 lordships.
We'll take up.
Yes.
Lord, seal number 41, my lords.
Forty-one.
And for the complaint, serial
41.
number 40.
41.
40.
40.
Yes.
Learned Advocate Mr. Srikanth MP stated that the order complied with.
Yes, your lordship.
In that view, nothing survives in the present contempt petition. It is accordingly disposed of as not surviving.
Serial number
49, my lords.
41, my lords.
49, my lord. May kindly be taken up any other day. Date could be fixed.
I'm for the tenant. May request for 17th or 18th, my lord.
49, 18.
Oblige.
Lord, seal number 41, my lords. 41. Next week, my lord. Seal number 41. 41.
In fact, your lordships have directed the parties to settle the matter, my lord. This is a case where there's a court order or dated.
My learned friend's submission was noted that he will take steps to try and find a way to settle.
What is it about?
The contempt.
Then we are ready, my lord. Next week, your lordship may have, my lord. If there's no settlement, we'll argue the matter. Date may be given.
19th March.
Please, my lord.
Serial number 38, my lord.
19.
Senior counsel is not there and also inform the additional general, my lord. Senior counsel also inform.
My lord,
Senior
this
counsel is
a-
not in
this is a
station.
Plum clearance board, my
That
lord.
is
where
ground matter. They have already.
Serial number 93.
Short date may be account date.
59 short date, my lord.
Sir, Madhyana, yeah.
Bill number 54, my lords, contempt petition, my lord. BBMP served a memo on me.
54.
54 minutes. And I pressed some time, my lords.
5-4 or 6?
54, 4 minutes.
What do you want? Time?
5th of next month, my lord.
5th of March.
Please, my lord.
5th of
That's
That's all.
serial number 69, my lord. I am referring for the complainant 69/1. This very urgency there, my lord. It is from 2004. Several directions were issued by this honorable court to delete the land. Now some small packet of land.
There is a delay of 62 days.
Yeah, that is the VDA. I have already filed counter to that. IA also, main objections also I have already filed, but it is not put up, my lord. Some urgency because since from 24 years, the food farmers are fighting. This is the third round of litigation. Second time we have filed for contempt petition, my lordship. A
Will
small
condemn.
packet of land island.
So delay shall be condemned?
I am for respondent 2 to 7.
Can we condone the delay?
Delaying, I have filed objections from. They have not
Objection.
put forth any
Then let
valid reasons.
it be heard. We'll hear. Yes.
Serial number 93, my lord.
90.
Short accommodations is next week, my lord. 2:30, my
What do you want?
lord. Short accommodation next week, my lord.
Next.
Please.
96? better.
93, my lord.
What is it? 96? It is a 96 petition.
My
Please.
lords, this is a matter, last date of hearing, I mentioned it, my lords. Matter, actually, it's closed on merits. But some monies are deposited by virtue of the earlier orders, my lords. For release of the same, we file applications. On the last date of hearing, the certain monies were released and we have started the primary health center. The impleading applicant, my lords, one Chamundeshwari Trust, they challenged the order of the DC before the appellate tribunal. They lose there. Now they have filed a writ petition that is under consideration. Here, my lords, they will not have any say, would be my respect.
My lord, I have not made a party, you will have to next week, my lord. Senior counsel is engaged in the matter. Tuesday or Wednesday, my lord.
No, let
First
us
time
say
coming.
It is about what?
PIL is already decided, my lord.
PIL is already decided.
Please
May I
come back.
may I
Please
submit
please
minutes?
for the purpose-
This is a matter, minutes. Your Lordship, kindly recollect, minutes. This is a matter where films that Dharmendra Miller, got the property. And the court then realized that the construction made was in violation of the Land Reforms Act. Therefore, Miller, a peculiar order was passed that additional 2% stamp duty shall be collected and that shall be used for any public funds, public properties. That's how nearly about 13 crores was collected. Thereafter, Miller, Deputy Commissioner made an application for asphalting the road. That was rejected with this honorable court. Then he made an application, Miller, for construction public health center. That was primary health center. That was granted. Thereafter, Miller, that was in respect of 4 acres of land. Suddenly, they make an application for a change of survey number. That was granted by your lordship. Now it is noticed.
This is directed to put up the petition with appropriate submission in writing
Please.
on
Before Monday, minutes,
on 5th of March.
5th of March.
With your lordship.
There is no practice here to put up with submit. For what purpose it comes out? This was a matter. No, make a separate sheet, not make. Separate sheet, submit. I'll just
With-
tell him.
With your lordship's kindly, serial number 81, please. It is for
81.
81. For council submission, I have not produced the certified copy of the annexure to be quashed because we are questioning the action of the authorities. In pursuance thereto, they have seized the vehicle and imposed penalty. There is no order itself. Therefore, that may be dispensed with, and the matter may be posted for preliminary hearing since there is an urgency.
What is to be dispensed? Certificate copy.
Yes,
Why? Certificate copy of posting.
because there is no order passed. We are questioning the action of the authorities.
All right, certified copy is dispensed with since there is no order is passed according to learned counsel for the petitioner, Mr. Assessment.
It may be posted for preliminary hearing,
Appeal may be posted on when? 11th March.
not a short date may be given, first time matter.
Still short date.
Because of this objection, it is posted in the objection, Lord. Otherwise, it would have been come in
So when do you want it then?
next week, please, Lord, because they are
Fourth-
seizing the
fourth-
vehicle.
fourth.
Obliged.
By 85.
All are here. Council is here.
Council is not there, my lord. Contesting respondents.
Original petitioner is not here.
Notes, I appeal for notes, the petitioner is concerned.
Yes, Mr.
Notes, they are not in notes, serve the copy of a writ appeal notes. Either notes the Lokayucta and these things.
What is?
Saying that copy has not been served.
Copy has not been served.
We have, we tried to reach him, but yes, I think the friend has not come to serve. But we will not, we are ready, it is here. Additional copies are here. We have already served, not 4 sets we have served, and the council was.
The council has changed. Earlier, another council was served. Now another.
Steps also. So totally 6 sets.
So you get the copy to your office, Mr.
Please notes, please note. I was just, yesterday when that's the reason notes I made a mention. So that notes I get an opportunity notes.
We want to proceed with this matter because there is.
Please, certainly I'll cooperate notes, certainly cooperate.
Put an end to either way. So tomorrow.
Please.
In the meantime, collect the copy. Tomorrow will
Not,
not.
may just have note day after tomorrow notes, kindly notes.
Pardon?
So that notes I can engage.
Pardon?
I can take the assistance of notes, any of the senior councils.
Engaging.
Day after tomorrow, all that day after tomorrow. Check.
Please.
At 2:30.
Please.
Day after tomorrow, we can start at 1 o'clock.
Very well.
Or let it be in the second half. Yes.
In fact, the inquiry against him, my lord, that is not the issue. So far as his inquiry is concerned, it can be stayed. But we are concerned about the effect
the
of
whole, yes.
My lord, 87, my lords, I appear, it's the same appeal, my lords. We have filed, the corporation has preferred an appeal. I have paid the court fees. Day after tomorrow, it may be listed, my lords. I will comply with all the office objections and serve the copies as well. Grateful.
Regular feedback.
First over matter, seal number 14, stay MC Basuraju. Number 14.
None was present in the first half as well as in the second session. The appeal was called out twice instead of full stop. Dismissing the appeal for want of prosecution, in the larger interest of justice, tend over to 28th March.
Till number 17, to H.V. Devraj.
Yeah, appear for the complaints.
So delay,
Delay, my lord, that notices has been served to the other side.
who appears?
That none appears, my lord.
None appears. So cell number 17, IA number 1 of 24. Or learned advocate Mr. So-and-so with the applicant. Those out with the notice of the court, none appears for the respondent. Paragraph. The prayer in this application is to condone the delay of 193 days which has taken place in preparing the appeal. The appellant as applicant Bangalore Electricity Supply Company Limited. Stated, explaining the passage of time leading to delay, inter-alia that learned advocate for the applicant intimated about the outcome of the writ petition and closing certified copy of the order. Thereafter, whereafter the file was forwarded to the legal section. The corporate office, legal section, recorded approval for filing the appeal and intimated the learned advocate to prepare the appeal. So nothing more is stated about the delay. It transpires that the delay took place because of the processing of the file at the corporate office level in the legal section. It is to be borne in mind that the applicant is an impersonate body where the decision-making process inherently consumes time to some extent. Full stop. Nobody has appeared on behalf of the respondent to oppose the paragraph. Any of the above circumstances obtained in totality, sufficient cause is made out to condone the delay of 193 days. Delay is condoned, application is allowed.
Merits that may kindly call it a week after next week, where the connected cases reserved by the division bench, that I will get the copy that you pronounced, that I will place it. That the single judge relying on the judgment of the coordination bench, the pronounced. That another connected appeal that which has been challenged. That after hearing the reserve the judgment, that if to pronounce that I will get the copy and I will place it on that.
Respondents are served, but none appears. When shall we give?
Week after next week, any date. Week after next week, any date, my kindly.
21st March.
Much.
$230 matters. Cell number 88, Mr. Lokesh KV. Cell number 88 for withdrawal of contempt.
Figures on record, memo of withdrawal dated 13/1/25 in which learned advocate for the appellant has stated on instructions that the petitioner wants to withdraw the contempt petition. In that view, permission is granted, full stop. Permission is granted to withdraw the petition, petitions and dismissed as before. Yes, next.
Yes. Number 89, Mr. Venkatesh Why?
Complaint. This is for not complying the direction of.
The
to
land
give
acquisition
compensation.
officer has already prepared, sent an endorsement, but this endorsement is not completely in compliance with the order passed by the land. The endorsement which has been already issued to the complainant, but per se is not in full compliance with the order passed by this honorable court. Such may grant me some more time, Lord, I'll have it.
Learned advocate.
My lord,
So and so, so and so.
it is
So
for
the- it's
15
stated
15
that
years.
The endorsement passed by the authority concerned in compliance of, in pursuance of the order of the learned single judge is not a proper compliance, and the press order is required to be passed. P6 time, post of time is granted, stand over to 27th of March.
Please. This is number 90. Petition for any.
In this case, my lord. My lord,
Respondent.
last hearing date to time to comply the order of this honorable court, my lord.
10 days, my lord. My humble request, my lord, 10 days my granted.
Since from 6 months I'm on street, my lord, I have no work, even though I'm having the learned single judge order, my lord, not to relieve from the service, my lord. It has been relieved on 3/8/2024, my lord. Page number 28, Annexure C, my lord, they are relieved from the services, my lord. The impugned order, my lord, page number 21, my lord. There's a specific order by this honorable court, my lord, not to relieve the petitioner, my lord.
Ten days, my lord, I will place the complaints affidavit without fail, my lord.
So time was granted after order was passed on 6/2/25. It was listed on 11/2/25. Time was granted. It is now coming up today. Today is what date? 18th of 19th. So many days have passed. And there is a direction that compliance will be obtained within 2 days, and the necessary orders will be passed, urging the contempt. Who is to pass the order? Number 3.
Number
Who is
1, my
number
lord.
3? Who is
Accused number 1, my lord.
Hmm?
Accused number 1 have to pass the order, my lord.
Who is accused?
Karnataka Residential Institution Society, my lord.
It is an admitted position.
Within 10 days, I will comply with it.
No.
We have already passed the order, my lord.
Then produce, then that's end of the matter.
Thereafter, my lord, the permanent employees questioned the transfer order, my lord. Transfer order, they have questioned before the Kalburgi bench, my lord. That order set aside by the learned single judge before the Kalburgi bench, my lord. Subsequently, we have direct the principal to take steps immediately. There is a communication we have made. At 10 days, I request, my lord.
You take him back in service, that's all, nothing more to be done.
That's the reason, my lord, 10 days, my lord, because without fail, I will comply the affidavit in 10 days, my lord.
Why 10 days?
My lord, there is an order of the Kalburgi bench, my lord. The complainant also is the part of the respondent in the petition, my lord. He is agreed to take the post in a different place, my lord. Therefore, the complainant is ready to take another post, my lord.
There was a
They have
specific
undertaken-
direction not to disturb the petition complainant here in my lord, not to disturb, give a post.
That order is not
They
released, my
are,
lord.
they
That's
are
what I
taken
request.
undertaking that will not disturb their post, my lord, but even though they have disturbed.
It is agreed before Kalburgi bench to
Please, my lord.
accept another post.
Please, my lord. There is an order passed by the Kalburgi bench, my lord.
The
That order
same
is-
day,
we
they
are waiting
undertake,
for
my
the
lord, the same day
releasing of
they'll
the
give
order, my lord.
appointment, they will take back me, my lord, the undertaken has been taken, that court also. But they have not, till today, they have not taken me back, my lord.
Only
No,
reason,
the counsel is saying that you agreed to go somewhere else.
please, my lord.
There is a specific order, my lord, saying that, I have undertaken, my lord, give me anywhere I'll work anta. But they have not given.
My lord,
there is a specific direction is given by the learned single judge before the trial.
They only appoint and they have said, my
Within
lord.
the
but-
25 kilometer of the radiation of the
So the
district.
direction is given in which kind of proceedings?
My lord, the, after we have transferred our permanent employee, we have transferred the some other place, my lord, his place, my lord. Subsequently, the transfer, our permanent employee is questioning that transfer order before the Kalburgi bench, my lord. He is also one of the respondent before the Kalburgi bench, my lord. The writ petition is disposed and allowed the writ petition and set aside our transfer order.
Filed by whom?
My lord, our permanent employees challenge the transfer order, my lord.
Which transfer order?
My lord,
Whose transfer order? Whose?
My, I submit, my lords. May I submit, my lord?
Who is
The-
appearing on your behalf in that proceeding?
I have appeared, my lord.
Kalburgi.
I have appeared, my lord. There is a specific direction and they have undertaken, my lord, we'll give a post. Same day, they said how to give it today only. They agreed, but till today they have not given.
It appears
Yes.
that in light of the proceedings before the Kalburgi bench, this may not survive.
No, it is
You
survive.
agreed to go somewhere. And they will be sending you wherever you want to.
That is also
Yes,
a
ma'am.
single bench order, my lord, saying that
You appoint, you reinstate him.
Please, my lord, based on the single judge before the High Court, my lord, we are placing the post, my lord.
On the single.
Only, my lord, only the order, we have to waiting for the order, my lord.
Why? You can subsequently do that.
My lord, the order is specifically undertaken, the school also, they have mentioned in the school also name.
First-
That order is not getting, my
First
lord.
you take back. And if. they are
Therefore, I
telling-
request only for 10 days, my lord. Meantime, I will.
No, we will not grant time. We will not grant time. You have to comply with this order, then
Please,
if
my
you,
lord, I will-
if you want to modify, vary your stand in accordance with the Kalburgi bench order, you can do it. We do not know what is the order, but 10 days we are not going to grant. We
least-
can,
At least 3 next Monday, my lord.
with a fine, my lord, fine may be imposed. I'm not having work,
order is
I
not,
have no salary, my lord.
So communicate the,
order is not available.
please, my lord.
Order is not
Order is not uploaded, my lord. That's what we
uploaded.
are waiting.
27th.
Please, my lord.
Fine may be imposed, my lord. Without salary, they are dragging me here, this
Let
court.
us see
and
what
that
the
court.
order, who is right. Order will speak it by itself.
In that order also they have undertaken, my lord. Will not disturb his possession. Will take him back today itself. That undertaken
my
is
lord.
taken before
So you
that
must-
court also, my lord.
My lord.
Right.
My-
So we'll record, and if you are turning out to be wrong.
No, my lord, I'm not turning up. My
No,
lord,
we record that.
my lord, we are not turning on this,
If,
my lord.
no, we record about what you are submitting about the
Please, my
Kalburgi
lord.
bench.
Please, my lord.
And if turns out to be wrong,
Writ petition number, my lord.
that statement turns out to be wrong,
Please, my lord.
will be heavily fined.
Please, my lord.
So Law and
petition
Advocate
number.
Mr. so and so while seeking time in this contempt petition stated that though the direction in herein is to take back the petitioner and not to relieve the petitioner from in a correspondent proceedings in
WP number 2
in the nature of WP number
20013 of 2025.
20001 of 25, 20001.
20013
of
of 2025. my lord.
So much petitions are filed in
Kalburgi.
2025.
13 only, my lord. It start from 2 series, my
2
lord.
series, my lord.
Kalburgi bench start from 2 series, my lord. Dharwad bench start from 1 series, my lord.
Pending before the Kalburgi bench in which the order is passed, wherein the present petitioner has agreed that he is ready to go wherever the
within the same district, Balki district.
We do not know. Let the order. 27. Everything is oral. 27 to be listed at 2:30.
Much.
91. Number 91.
Next, my lord.
So Madanagoda, Mr. Party.
No, for complaint in this case, Your Lordship.
Yes. In this, my lord, last occasion I filed a complaint affidavit. My lord is directed to place the order with regarding to posting.
A similar matter has that of the serial number 90, Your Lordship. The complaint was relieved from the service, my lord. Where it was specific directions not to review the complaint from the duty, Your Lordship.
Now, what is the, let us see what is the compliance.
Page number 5, my lord.
So he is back in service.
Please, my lord.
Then what remains, Mr.?
My lord, what they are doing is not in connected matters, my lord. They take me to duty, my lord, and subsequently after disposal of the contempt petition, my lord, again they are relieved, my lord. In two complaints, Your Lordship, 1098 and 1097, Your Lordship. They have taken back me for duty after filing the contempt, and thereafter, my lord, they have relieved me, my lord. I am filing, in those cases, I am filing application for recall of the order of the contempt, Your Lordship. Similar things are doing, my lord. That is a specific directions to be issued to not to relieve the complaint.
Daily rated work.
My lord.
Daily rated work.
My lord is outsource agency.
Outsource agency.
The guest lecturer, my lord. Page number 5, they himself is a give a letter before the principal. Translated copy of page number 6, my lord.
We record that he is continuing.
Please.
Please.
Attendance register also is placed before this court, my lord.
Correct.
January.
Please, my lord, but not to relieve, my lord, subsequently, my lord, after disposal of the petition, let them not relieve me from the duty until the fresh things.
The direction in the order of plantation will be dated 21st February 2024 was to require the respondents not to relieve the petitioner if still rendering the services in the respondent society. Complaint was the contempt petition was filed complaining that though on the date of the order the petitioner was in service, his services came to be relieved. Today, when petition came to consider as learned advocate Mr. So-and-so, for the respondent number 2 files memo of certain documents which inter-alia includes the communication sent by the petitioner to the respondent, the school, what is that?
Respondent number 2, my lord.
School,
my lord.
School, as well as the, it also includes the copy of the attendance register signed by the complainant from January for the month of January and February 2025. The above attendance register indicates that the petitioner is taken back in service and that he has been continued in service. Full stop. This position was not disputed by learned advocate for the petitioner. In the aforesaid view, when the petitioner is back in service and is retained in service, contempt petition does not survive, it is accordingly disposed.
Much.
Please.
Number 92. So Shivprasad Shantanagoda.
My lords, for the complainant, my lords, on the last date of hearing, my lords had sought instructions whether accused number 2 is still in the current post or not. On the last date of hearing, my lords had sought whether accused number 2 is currently still in his post or he has changed. So,
The accused, who is this
The
one?
accused, the earlier,
Tasildar, my lords.
he is retired from services, my lords. My instructions, my lords, presently the accused number 2, which is mentioned in the cost letter, my lords, is now is retired, my lords, and another new Tashildar has come, my lords. But the order to be effected is by the special Tashildar, my lord. Presently, the said post is vacant, my lords. To effect the kata in the name of the petitioner, my lords. The one name shown as Narsimha Murthy as accused number 2 is no more in services, my lords.
Little loud.
My lords, one name shown as Narsimha Murthy as accused number 2 in the cost letter, my lords, is no more in services, is retired, my lords. Now the another person has come, but the person who has to effect the kata in the name of the petitioner as per the direction of the learned signature order, my lords, special deputy commissioner, special Tashildar, my lords. Now the special Tashildar post has been vacant, my lords.
But there will be an in-charge officer, right? See, no government post remains vacant. Vacant in the sense there will always be an in-charge officer.
Lords, the actual difficulty is that, my lord, the person who was holding the post of special Tashildar, my lords, 10 days before he has been suspended from services, my lords.
Fine if he is removed or dismissed or suspended or transferred or retired. That in charge someone will be placed.
Please, my lord, by my
Now, who is that in charge officer?
Other instructions, my lords, on 18/12/2024, the then Tashildar has already issued an endorsement, my lords, to state that there is an appeal pending before the special deputy commissioner court, my lords. In view of the same, it cannot be affected, but that is against the order passed by the learned single judge order, my lords. The learned single judge specifically stated that the kata has to be affected in the name of the petitioner, my lords. It appears to be not proper. That's the reason I want to secure some instructions, further instructions, my lords. On 18/12/2024, an endorsement has been issued, my lords. That is
not securing instructions. Here it is compliance of
Please,
the
madam.
order passed. And in contempt, whichever officers who are in contempt are liable.
Please, my lords.
But the
Now
specific
that is-
direction of the learned single judge to mutate the kata in the name of complainants.
Some time is granted, my lords. I'll ensure that the orders will be complied, my lords.
You provide who is the consent officer, he will implement them in the contempt matter.
Please, my lords. I'll provide, my lords. On Mr.
Leave to
Shreyas,
amend the course title by emblazing the respondent contemnant by name. Such amendments will be carried out within 1 week. The petition will be posted next on 27th of March.
please.
Please, madam. I'll file the necessary application.
93 is urgent. Number 94. Srimati Geeta Devi.
Lord, in this matter, my lord, we're challenging the order of the learned single judge. Directing the corporation to provide certain medical reimbursement to the petitioners. Lord, we have contended, my lord, he is not a regular employee of the corporation. He was working with the Karnataka Water Supply Board. And when the work of maintenance of water and drainage was transferred from Water Supply Board to the corporation, these employees were also made over to the corporation. Now, these employees had sought for regularization, and at that time, the government had considered and not granted them the regularization because they could not be regularized. So based on the Contract Labor Abolition Act, my lord, certain time scale was given. Allowances equivalent to that of the employees of the corporation was given to them. Based on that, my lord, now we have given, they have been given that benefit in 2012. Now, according to that, my lord, they were not given any other benefits. So therefore, my lord, medical benefits could not be given to them. And so we had rejected that, my lord. And that was challenged before the learned single judge, and the learned single judge has relied upon the Contract Labor Regulation Act of 1970. And I said, if a contract labor would be given the same benefit, if you're working on a regular establishment, even an employee of the corporation should be given that. So the major difficulty was, my lord, that he is not a regular employee. He was not employed by the corporation. And therefore, we could not give this benefit, my lord. When we wrote to the government to seek clarification, the government was the opinion, my lord, that all the corporations, the similar circumstances, situations are there. And therefore, my lord, this issue has to be clarified with honorable court, my lord.
It is an IA for condemnation of delay. There is an IA for condemnation of delay.
What condemnation?
That is not at.
62 days.
62 days deal.
Delay is condemned. For learner educate means so and so for the applicant and reads and only respondent and learner educate must be so and so the respondent or is petition. Delay of 162 days which is said to be condemned. This application is explained the accompanying affidavit wherein the applicant Mysore City Corporation has stated that pursuant to order of the corporation obtained opinion about the feasibility of preparing appeal. The corporation addressed letter 13 to 24 to the state government. It is stated that the state government and the government.
But as per our rules also, my lord, the definition of an employee, I would like to just bring that, my lord, that is only the employed directly by the corporation or absorbed into the services. These petitioners are not absorbed in the services, my lord, and therefore they would not be entitled as one submission and it is one court.
Will dictate in the chamber. Yes. Appeal shall be listed on 27th March.
Number 95.
Lord, your lordship, I have
Rajendra
it
KR.
a week after that, my lord, the 27th March, I'm not.
8th April.
Number 95. Mr. Rajendra KR.
In the chamber.
My lord, on submission, my lord.
Yes.
The counsel for the appellant has appointed as a government pleader in High Court of Karnataka, my lord. But we intimate the same to the appellants to take back the file and with NOC, my lord. But yet they are not come our office, my lord.
So delay, 40 days delay.
Yes.
The facts of the case and having heard learned counsel with parties, delay is explained. So notice will have to go to the appellant. It was stated at the bar that the counsel who was appearing for the appellant applicant has been appointed as additional government advocate. In that way, there shall be notice to the appellant to make alternative arrangement. Notice shall will be returnable on 28th of March.
Number 36. To Madhusudan Adiga.
Appearing for respondent number 8, your lordship.
Number 36.
Nobody is there. Yeah, like.
Lordships, in the last hearing, you had directed us to file a new fresh representation. In compliance to that, I have filed a new representation to the ASI, your lordship. Respondent number 4 to 7. In the same, I have also mentioned that I am willing to reduce 5 feet height of the minarets.
Who is for the petitioner?
Madhusudan Adiga.
He was there. Some other day. 25th of March. March.
37 is urgent. Number 38. Mr. Rajesh Gowda.
Senior is not in station. We engaged senior councilman. Also filed a rejoinder
The preliminary objection to this is, my lords, the petitioner having filed an application for grant of the very same land, having got rejected, my lords, has sought to file this public interest.
We failed with the rejoinder and we categorically stated that is not the signature of the petitioner. In this, we filed an application also. We filed application.
So he filed application for grant of very.
Grant of land, my lord, which came to be rejected, pursuant to which this writ petition has been filed, my lord. Now the question is, the land belongs to the state government, my lords. It has given to the Slum Clearance Board under section 7.
Where is the application of petition?
That is, my lord, that is annexure R3. We have produced it along with our statement of objection and the endorsement. My lords. Annexure R10, page 46. For the statement of objections, my lord. The typed translated copy is at page 48. My lord.
Next week, we engage senior is not in station. Senior counsel. Expected to take a date on next week, any date, And we also filed the rejoinder yesterday in the counter. Okay. So the state copy. State copy is so copy. And there are the already representation given more than 12 institutions has given a representation to the respondent. Respondent number 1, 2, 3, which has not been considered. They also drawn, what is it? They also sent all the representation to the chief secretary in this regard. From 2011 onwards, my lord.
Annexure R10, my lord, at page 53 of the statement of objections, my lord. That is the endorsement given insofar as the first petitioner is concerned, my lord, Jayamma. Page 53. The statement.
This 53 is the endorsement given. Janata Darshan before the
page 4. Page 53, Manoj. Karnataka Slum Clearance, Karnataka Slum Development Board endorsement regarding request for allotment of site under ASHA scheme in survey number 89, 4 acres, 15 guntas, my lords. With reference to above subject, Janata Darshan was held by so and so and so. You have submitted a representation for allotment of site under ASHA scheme and in survey number 89, measuring 4 acres, 15 guntas situated so and so, which is earmarked for rehabilitation of residents of Jyoti Nagar slum area for so and so. On examination, it is hereby informed that your allotment of site under ASHA scheme is not within the purview. Jayamma, who is the second petitioner, my lords. First petitioner, I'm sorry, my lord. And insofar as the first petitioner also has given a representation, my lord, that also has been rejected. Now, subsequently, my lord, ultimately, my lords, houses have also been constructed, my lords. I'll show the memo, my lord, without concealing that fact.
We also filed. In page number 63.
This is the current situation of the land slum dwellers, my lords. And they have no right, my lord. There's no public, actually it's properly belonging to the state, giving to the slum clearer for their rehabilitation. In fact, if we had not given to them, they should have filed a public interest in the interest of the slum dwellers. Public interest is created for slum dwellers who cannot approach this court. They're acting against public interest, my lord. Without concealing this fact, they are aware of this when they filed the petition.
Petitioner,
My lord.
is it a pro bono work, what you are doing?
No, but we are not after all those things. My
No,
lord.
no, no. Is it a pro bono work, what you are doing? No, it is not. Now, these persons, they request for grant of a small piece of land under Rashtriya scheme. Two of them. That means to say they are not well-to-do
No, madam.
and they engage the services of a senior counsel.
So because of senior
And they want
counsel,
4 acres under Ashes.
for free of cost senior counsel is doing, but because of the we request the senior counsel. He's not charging anything, my lord. He's not charging anything. The only thing is that, my lord, as per 52,
We read between the lines.
no, as per page number 52, we are not given any representation. Where is the representation? We don't know, my lord. They issued only endorsement 52 in page number 52. Where is that representation we have given to the Janta Darshana, to the chief minister? Where is
Yes,
that
yes.
representation?
46, there is a,
My lord, that with respect to petition number 2, they're saying, this is not the signature of the petitioner number 2. This is not the signature of the petition number 2, which categorically mentioned in the rejoinder. Yesterday we filed the rejoinder, my lord. We categorically stated in the rejoinder that this is not the signature of the petition number 2. In this regard, she will file an affidavit, my lord.
Which signature?
In page number 47, there is a signature of Radha. There is a signature of Radha.
That
This
we don't know.
this is not the signature of the,
Anyway, you are arguing better than your seniors. Proceed.
my lord, no, my lord. We engage here, my lord. Next week, any date, my lord. Because of the senior is not charging anything, because he told that he will argue on the next date, but he went to Prayagraj somewhere.
Prayagraj.
Dear Ravi Shankar sir. Dear Ravi Shankar sir went to Prayagraj. That is the reason only, that's the reason only morning I seek the adjournment, my lord. And instructed senior, he said, you can take next week.
You
any
did not go with him.
Huh?
You did not go with your senior.
I have to take date here, my lord. Senior, you take date here, I will go. Sir. Yes, there is also some- Signature is also similar.
signature is also very similar.
The Wakalat.
No, no, I don't, even the petition signature.
Petition.
That is not the signature of the petition. In this regard, we also filed an application. Taken 359 of BNSS. We filed application. It's not the signature of the petitioner number 2. Now the senior is claiming that perhaps page number 52. Where is that application we have given before the Janta?
That is a, that is
Janta
a,
session? There is no such application. The only thing
we have got the
is
application
endorsement.
copy also.
The endorsement we have produced, Mal. The endorsement has been produced. We have not filed any application. We filed application to resecure the land for the playground, Mal. That's only we filed before the Janta Darshan, not for
Assuming-
allotment of site.
Forget it, all that is that the interim order has been granted on the basis of non-compliance of section 71 of the Land Revenue Act. The impugned order shows that we are complied with section 71 of the Land Revenue Act. The state government has given it to the Slum Clearance Board. That formality has been completed. It is between the state government and the Slum Clearance Board. They have no semblance of right or whatsoever to prevent from giving it to a Slum Clearance Board, my lord, and at the weakest of the weakest people in the society. On merits also, my lord. How can they act against the slum clearance
As per the
people?
judgment, there is a judgment in my lordship has been put to the judgment of the Dr. B.R. Ambedkar Dalita Indugala Alpa Sankyata. The scheme, Ashraya scheme has been lapsed by Supreme Court. Honorable Supreme Affects Court, my lord. In this regard, the judgment has been quoted, my lordship, on when the interim order was granted. But my humble submission.
We have followed this judgment, my lord. Strictly in terms of your lordship judgment, we have followed, and I'll produce documents to show that this is what my learned friend is relying upon. That is that paragraph 7. We are complied with it, that your lordships will get it.
My only submission, my lord. The senior counsel is arguing. My senior counsel has let them argue on the next date of hearing. That only a humble request. Any date of the next week, my lord.
No, no, only because the nature of ground you mentioned, we are not going to take, not going to give time. Only because the nature of the ground you mentioned, we are not going to give the time.
Lord, because I don't have any instructions from the senior. Contacted him, he told him.
You said that your senior has gone to some religious place. Where?
Morning, I came to know that he went to
What is the relevance of this in this High Court? How can you argue? What is the standing? What is your standing in the bar? What kind of ground you are urging with the High Court?
Sorry, apologies. Because of.
Maintain the discipline of
Sorry.
your language and ground and everything.
Apologies.
What is the relevance of that going to there as a ground to seek the adjournment?
Apologies.
Why should your son should not be cancelled?
Apologies.
You must know what to mention and what to not mention.
Apologies.
Whatever may be the ground, Mr. Counsel.
A sincere apology.
We don't want apology. We want discipline from you.
Sorry.
We are taking in lighter way. That doesn't mean that you can speak anything and everything.
I'm not.
And urge anything ground. I have gone to trial court and I have gone to here and there. There is no ground because the High Court to mention. Maintain your own decorum, much less ours. I'm very touchy about all these things, as far as I am concerned. Yes, when do you want? At the request of learned advocate petitioner, stand over to 12th of March. This is too much.
I am sorry, ma'am. I'm extremely sorry. I'm up. See, apologies, ma'am. I am not knowing that the senior is not. That is the only thing. I'm not aware that senior. Morning I came to know. That's the only thing.
That is not the question.
I sincerely apologize, ma'am.
Unnecessarily making the court exasperated. By you making useless grounds and mentioning anything you want. Yes, next.
So 39 to 41 are
If I
against
may
number
request,
42.
if your lordship's calendar, any day before 12th March, it will be, if possible.
10.
Leave it, please.
A sincere apology.
Number 42. Just Sandeep Larry.
Madam, my lord.
Yes.
Madam, may I request for a short accommodation, my lord?
Why? 42. You are for petitioner?
Please, my lord, I'm the complainant, my lord.
For respondent number 3, my lord, I have just filed my wakalatnama. For R3, my lord.
Pardon?
And for respondent number 3, my lord, I have just filed my wakalatnama. They're getting led by objection.
When shall we keep? 17th March?
My lord, may I request for 18th or 19th, my lord?
19th March.
Grateful, my lord.
Obliged.
Number 43 is urgent. Number 44. Mr. Harish NR.
Fair for petitioner, madam. And in this case, madam, last date of hearing, this honorable court was pleased to make observation, serious observation.
Yes.
Madam, regarding the kindly see, order dated 24. 24/9 to 21/2025.
What happened to first appeal?
A short accommodation may be granted, your lordship. To comply.
Look at the order last time passed. You are Miss Latha. Latha.
Your lordship.
What's your good name?
I can't.
Name.
Arshita, your lordship.
Yes, last time you did not appear.
No, your lordship.
So you read the order. Regular first appeal has been dismissed for want of prosecution. What is happening now?
My lord,
You must be aware.
my lord, with petition, there is a direction to consider my representation. My lord, appeal came to.
You want time, what do you say?
Sorry. Please, my lord.
At the request of learned so and so, so and so. But on that day, you come with specific
Yes, your
instructions.
lordship.
Read the order last time passed.
Yes, your
Send
lordship.
over to 20th March.
Forty-five is urgent. Number 46. Mr. Akash VT. Number 46.
46, I appear for complainant in this matter, my lord. The order passed by this honorable court are complied, my lord. The petition may be disposed of.
You are for complainant?
Yes, my lord, I'm for complainant.
Learned advocates, what is your good name? So and so for, what is your good, Yashaswini? S.
Yes, my lord.
For learned advocate, Mr. Akash VT stated that the order under contempt is complied with. Therefore, the contempt does not survive. Learned additional government advocate, Mr. Raghavendra, simultaneously. What is this? Produces copy of the order transferring the khata. Transferring the khata, which is taken on record. Full stop. In view of the above, the contempt petition does not survive and is disposed of accordingly.
Much obliged, my lord.
Number 47, Mr. Ramesh KR.
Appear for complainant in this matter, my lord. Not
Yes.
non-compliance of order passed by the single judge.
Resolved where? By us?
Paragraph 6, page 26. The last portion, my lords.
Paragraph 6, page 26.
Page 26, my lords. Now the DDLR has heard and reserved for orders, my lords. If 2 weeks' time is granted, orders will be passed, my lords.
Where is that result?
My lords, it is the duty of the respondent 56 to effect the 11 sketch in the subject matter of the land in the question, taking into the considered revenue documents from the competent authority and complete the entire proceedings within an outer limit of 4 months from the date of the receipt of the copy of the order, my lords. Now the inquiry has been has been done, my lords, and orders is yet to be passed, my lords.
So
2 weeks' time is granted, it will be passed, my lords.
It can be disposed of.
No, my lord, they have not completed the order. My lord, this is the second time writ petition, my lord. Earlier, I have filed a writ petition, writ of mandamus. Then, my lord, they have stated one endorsement, stating that, my lord, there is a discrepancy in the Akarband and service documents.
What order?
Then, my lord, I have challenged the said endorsement. Sorry.
What order is it?
My lords, to give the 11 sketch, my lords.
Then is to
Please, my lords. To effect
the
11 sketch in the spirit of the matter, taking into the consideration revenue documents from the competent authorities, my lords. He has collected the documents from the other authorities, my lords, and has reserved it for orders, my lords. That will be completed within 2 weeks, my lord. 2 weeks' time is granted, my lords. The order will be completed, my lords. That is my instructions, my lords. The DDLR is the competent person to get to fix, my lords.
The petitions will be listed on 18th of March at 2:30. Since learned additional government advocate Mr. Raghavendra stated that the order shall be complied with.
Please, please, I'll report compliance, my lords, please.
Number 48, Mr. Jagdish Shastri.
Yes.
For respondent 2, my lords, file a compliance affidavit, my lords. This is the matter.
Respondent,
For respondent number 2, my lords.
what is the position of compliance?
Let's will comply the same, my lords.
Complied with?
Complied with, my lords. Office objections have been raised on the compliance affidavit that's been filed, my lords. Okay.
Sorry. Take rest. Sit down, sir.
I fell down. I fell down here.
Therefore, sit down. We'll take one after one matter, sir. Next.
49 is urgent. Still number 50, Mr. H.C. Shuram. Still number 50.
In this matter, my lords, I have filed a memo, my lords. Order has been complied, my lords. Your lordship may kindly see my memo dated 5th February 2025, my lords. On 31/20/25, my lords, license has been accorded in favor of the complainant, my lords, pertaining to the fair price shop, my lords.
What is uploaded?
Memo dated 5th February 2025, my lords.
So is granted fair price, not granted?
It's granted, my lord. 30th January 2025, it has been granted, my lords. I have passed. The grievance of the complainant was that license was not accorded to her, my
No,
lords.
this is compassionate appointment.
On compassionate ground, my lords, she sought for grant of license for fair price depot, my lords.
No, you have to reconsider the application. It is done.
Please, my lords, we considered on 30th of January 2025, we have issued this order in license in favor of the complainant, my lords.
And
my lords.
what is the order passed?
That a license has been given to her, my lord, for to run a fair price depot, my lords, under public distribution system, PDS, my lords. Relevant portion, my lords, you would get it at page number 7, my lords. Translated part, my lords.
Transfer of authorized.
Please, my lords.
Yes. Loan and additional government advocate. Mr. Raghavendra stated with reference to the compliance affidavit filed that the application of the petitioner has been reconsidered as directed by the single judge, and order public endorsement dated 30th January 2020 is passed, whereby the petition is granted the
Please,
authorization
in favor of the complainant,
of the
granted, my
fair
lords.
price of post of this marks compliance of the order. However, since learned the petition is not present, full stop. In order to give opportunity to learned advocate for the petitioner to respond and make submission, come as a last chance, put up at 2:30 on 20th, tomorrow.
Please, my lords.
So number 51. Number 51. CH-1 Pradeep for.
The order passed by the learned single judge has been complied, and brought the endorsement issued by the Bangalore Development Authority has subsequently been challenged by the complainant in WP 30828 of 2024. I filed a compliance affidavit also.
Yes, Mr.
My lordship, senior is engaged in another court, my lordship, requesting a week time.
Pardon?
Senior is engaged in.
No, there is nothing to be voted. Let us see what there is. You can also handle.
Kindly the matter
Very
be
simple.
passed over, my lordship. Passed.
No, we'll read together. Let us see. What is the direction? Go to page 39. By directing the BDA, you are for BDA.
I appear for the BDM.
BDA to
Not-
consider the case of the petition in light of the provisions of section 38D
38D of the,
in light of the interim order passed by the division bench, so and so within the outer limit of 8 weeks. Now, what order you
Please.
have passed?
but I have passed an order, my lord, I filed a compliance affidavit, my lord, and endorsement dated 28/2024. Lord, Lakshmi, kindly take page 4 of my compliance affidavit, translation, Lord, at that page 5. What was permitted by the learned single judge is to avail section 38B benefit. The maximum which I could have regularized is 4,000 square feet. But the petitioner seeks for regularization of 1 acre 7 guntas, which I reject. My lord. And this endorsement is in challenge before the
No
learned
tra-
sing.
There is no translation.
I have, my lord. First, I filed a memo, my lord, subsequently, first I had filed a memo, my lord, subsequently an affidavit is filed. Sorry, if I'm. Satish, sir. My apologies.
That is dated 28 to 24.
Yes.
Translation?
Translation, Lord, I had provided, Lord, may permit me to pass on the translation.
What is the order endorsement?
Lord, the endorsement says, Lord, that under 38D, Lord, your request for regularization of 1 acre 7 guntas is not permissible, as the section provides for regularization of only 4,000 square feet of a land. May I pass on the translation? May I pass on the translation? Sorry, my apologies.
lordship, senior is on his feet, my lordship, to kindly pass over. Just kindly pass over. 1 minute, he'll be here, any moment he'll be.
What is your name? You are good enough to argue. Why not arguing?
Lordship, I'm not instructed to argue, my lordship, still.
You don't have file.
My lordship,
You got papers.
I got the papers.
What is this? Give copy to.
I have given. I've already, he has. The endorsement is again under challenge.
Are you carrying the file or not?
My lordship, carrying-
You are not having it. Where is it?
No, my
Where is your
lordship,
file?
I've carried the file, my lordship. File is here, my lordship. But I'm not instructed to.
Sorry, my lord, I was held up now. The writ, my lord, the contempt may be closed, my lord. Contempt may be closed.
Learned advocate Mr. So-and-so fairly stated that the directions and brought under contempt jurisdictions complied with since endorsement dated 20/20/2024 is issued by the respondent under section 38D of the Bangalore Development Act 1960. Post of, in view of the above statement, contempt petition does not survive and disposed of.
Lord, that endorsement was challenged, my lord, that same has been set aside, my lord, the single judge.
Set aside.
Set aside. That may also be recorded. That has been set aside, and my lord, please.
Next, it was additionally submitted that said endorsement, however, has been set aside by learned single judge in a writ petition which was allowed.
Please move on.
In any contempt does not serve.
Liberty may be granted.
What liberty?
Lord, there is another, my lord, direction to, my lord, reconsider the matter, my lord. Necessary, my lord.
Any further development in the subject matter shall give fresh cause of protection to the petitioner to institute appropriate legal procedure, if so advised.
Number 48. Jagdish Shastri. For response number 2, my lords.
Lords, now they all allow me to work. What is there is only oral, my lord.
My lords, it's been complied, my lords. The earlier posting to a different person has been withdrawn, my lords. At Anitishar A, my lords, of the compliance affidavit, 30/1/2025. There was a fresh appointment that was made, my lords. That has been withdrawn, my lords. And subsequently, in view of this particular order, the complainant is permitted to work in the said.
Page 5.
Page 5, my lords. Yes, ma'am. In fact, the complaint is working in the said school at this point, my lords.
It was stated before the court that the petitioner is taken back in service.
Apologies, my lords.
Taken back in service.
Taken back in service, my lords.
Taken
He's already taken
service
back. in
and
service.
that she has been working.
He's been working.
The statement of fact was not disputed by learned advocate for the petitioner, Mr. So-and-so, so-and-so.
My lord, salary is not given out. Salary.
The contempt petition is disposed of.
Interim order doesn't specify.
But in the affidavit, they are not stated anywhere to taken back.
We'll say nothing further is required to be done in this contempt petition since learned advocate Mr. So-and-so, the respondent stated that the petitioner are taken back in service, which factum would not be disputed by learned advocate for the petitioner, so-and-so, so-and-so. Petition is disposed of according, without going to any aspect of the merit, including the maintainability.
Obliged. Lord, one submission, Lord. In respect of writ appeal branch, there is no place, my lord, to sit. Kindly look at into that, my lord. I request this.
What?
In court, in writ appeal branch, there is no place for say sitting or compliance of the office objection, Lord. Is the PIL kindly be oral PIL?
No space.
No space, my lord. One file also not be there. file in the file also with for lot of, my lord, there is no place to work out
In which department?
in writ appeal bench. Writ appeal bench. Kindly see that.
We'll see.
His overall PL, kindly be considered. Oblige, Your Worship.
Cell number 52, Mr. GM Srinivas Reddy. Complainant.
Yes.
The missing committee has been constituted, my lords, and proceedings are going on, my lords. The documents were earlier was placed before the
Which committee?
missing committee, my lords. The earlier documents were given to the Karnataka Appellate Tribunal, my lords. The documents have been secured from the Karnataka Appellate Tribunal. The proceedings have been started, my lords.
We'll wait for some.
Please, my lord, 2 weeks, my lord, since to July, my lords, we are waiting for their lords order.
Since the compliance is under consideration, under process, under process.
Under process, my
Send out to
further instructions, my lords, they are not appearing before the missing committee, my lords. That-
27th.
And they
No,
come,
we are appearing, my lords. They have not issued
That
any
is the-
notice.
27th March.
please, my lords, we'll report compliance.
53, Mr. Nagaraj GH.
So 27 March.
54 is urgent. Cell number 55, Mr. Chetan Jadhav. Cell number 50. Mr. Chetan Jadhav.
Appear before the petitioner, my lords.
Contempt petition, my lords, because the FIR was filed in 2019, my lords. Till date, they have not filed the charge sheet. Hence, we had filed a writ petition before this honorable court, my lords. This writ petition was disposed of on 24/6/2024, asking the respondents to file charge sheet within 4 weeks.
Who are you, complainant?
Yes, my lords.
No, no, in the current proceedings also complainant.
Yes, my lords.
Yes, Mr.
My lords,
What is going on? Take instruction.
I take instruction, my lord. Notice is not yet issued to the respondents, my lord.
Notice is issued.
I'm sorry, my lords, because
Only
my
number
instruction is
three.
that notice is not issued. Permit to take notice to R1 to,
Notice is issued only to number 3, who is probably police inspector.
Please, my lords.
Investigating.
Please, my lords, I'll take
No.
further instruction.
Oh,
Thank you.
police inspector.
Respond number 3, my lords.
Take it. Instruction.
Please, my lords, I'll take it.
When? 4th March or 5th
Please,
March?
March.
March, 4th March.
Please.
Beautiful March. Now, stand out to 4th March in order to enable. And additional government, Raghavendra, take instruction regarding components.
Yes. Cell number 56, Mr. Suresh K. Desai.
For the complainant, my lord. The order is at page number 36.
In this matter, my lords, notice has been issued, my lords, by the special and acquisition officer, my lords. And next date is hearing fixed on 25/2, my lords, for hearing. Notice is issued. Please, my lords.
Today, after filing this contempt petition, they have initiated.
Which court is free? We have issued it.
No, my lords, now the special land acquisition officer is issued a notice, my lords.
Which court has issued notice?
My lords,
Which court has issued notice?
special land acquisition officer, my lords. SL was issued a notice, my lord, fixing hearing date, my lords.
What is the direction?
Please, my lords.
He was directed to conduct an inquiry, my lord. Clear direction, page number 36, the orders at page number 36, my lord.
But you were supposed to do within 4 months.
Please, my lord, there was some delay, my lords, in this.
All that we'll keeping it on 25th of March and we'll monitor the progress.
Lord, a
So it is-
similar complaint has been lodged by other respondent, it has appeared in the serial list number 76.
But they have initiated the inquiry.
No, that can be clubbed along with this, my lord. Serial number 76 also, when a complaint has been lodged, that can be clubbed along with this petition, my lord.
76 also
Yes.
to be listed on
7.
same date
76,
with
26.
contempt petition number
Please.
138 of 2024. Yes.
Number 57, Mr. Basuraj Patel GK.
Planning. It has not complied the order passed by this court. Complaints affidavit is filed on 17 February 2025, my lords. Copy was not. I go through the affidavit and make submission. I filed
Today I
complaints
received-
affidavit on 17 February, my lords. Copy is served today, my lords. 2 weeks, I make a submission.
No,
Go
no.
through.
Make right. now. What is this? Let us see. 24/3. If it is worth giving time, we'll give time, otherwise not give.
Direction, page number 14, my lord, para 5. The land council for the submit that submit a representation within the next 4 weeks seeking deletion of the name of the petitioner from the list of rowdies. If that be so, the second response shall consider the same and pass necessary orders in accordance with law, bearing in mind guidelines issued by law laid down by this.
His name has been deleted from the rowdy sheeter, my lord. His representation was to consider that his name to be deleted from the rowdy sheeter, my lords. That has been complained, I have been complained, my lords. Lordship may see Arashar R1, his name has been deleted from the rowdy sheeter, my lords. The grievance of the complaint has been complied, my lord. Lordship, kindly see paragraph number 3 of my complaints affidavit.
He wants time. 27th of, 8th of, April, 24th April.
So number 58, Mr. Abhinav V.
For the appellant, notice against the R3 and 4 has been not served.
Notice not received back.
Returned is come out. May I take the standing counsel take out?
No, not come back.
May I request this lordship to direct Monish Kumar to be served because they are the standing counsel for BWSSP. May I request the honorable to take notice for BW.
Notice in respect of respondent 3 to 5 may be served on the council appearance.
Please, Monish Kumar.
There we. In addition to normal mode of service. Yes, in addition, yes.
There's a delay of 70 days that can be.
When do you want? 21st March.
Please.
So number 59, Mr. K. Krishna.
The appellant, notice issued to the first respondent was awaited. Notice issued to the first respondent was awaited, my lord. It was not yet served. Notice to the first respondent herein was issued, my lord. The office, it was awaited, my lord. In the meantime, I may be permitted to serve the copy to the counsel who represented the petitioner in before the learned single judge.
You serve them.
Yes.
Lordship, I am appearing for respondent 2 to 7 in the writ appeal and contempt. I am a complainant. This is the third round of litigation, my lordship. Appeal number 59.
So what shall we do?
Service is over.
Yes, next. Give some date.
60 is urgent. So number 61. 61, Mr. Satish K.
It's 3rd March, 23rd April.
62, Mr. Keshav M. Datar.
Office objections have been complied with. Only thing is translated copy and the typed copy has to be furnished. Seek about 3 weeks time, my lords.
Within 3 weeks, the office of justice will comply with. From whereafter the appeal is registered for the court as per roster.
May I make a request, Your
For
Lordship?
4 weeks, my lords, if
I
your
have
lordships
filed
would
vacating
apply.
application. in
Because
this-
the volume, there are voluminous documents, my lords. 4 weeks.
May,
It's interim order to be extended, my lords.
Interim order.
may I
granted
make a
by
submission, Your Lordships, in this?
Grateful.
I have filed vacating application, Your Lordship. There is some urgency to the petitioner's hearing. The respondent number 6 was the petitioner before the Honorable Learned Single Judge. The issue before the Honorable Learned Single Judge was, Your Lordship, I had purchased this property under registered sale deed in the year 2010. And in the year 2019, I make an application before the Deputy Commissioner seeking for conversion of the said land. When that application was pending before the Deputy Commissioner, one stranger files a complaint gives a complaint to the sitting MLA of Tirthalli Taluk, who is also a member of respondent number 5 corporation. He gives a complaint. That complaint, as a member of respondent number 5, he forwards that complaint to the chairman. Chairman on the very complaint passes an order of status quo. And thereafter, he directs Deputy Commissioner not to proceed with that application. And then based on that status quo order passed by the committee, which was without authority and jurisdiction, the Deputy Commissioner issues an endorsement stating that since there is an order of status quo, your application for conversion cannot be granted. I approach this Honorable Court challenging that endorsement. The appellant herein, who claims to be who is an original owner, and he has executed a sale deed to my vendor, and there are several transactions which have taken place. After lapse of 30 years, when the writ petition was pending before the Honorable Learned Single Judge, he makes an application, files an application seeking for impleading him as a party respondent to the writ petition. That application comes to be rejected by the Honorable Learned Single Judge. He doesn't challenge that order. Till today, that order has attained finality since he has not challenged the impleading application, the order passed on the impleading application. Without disclosing all those facts, he has filed and he claims to be the owner and he has filed a suit. That suit is pending for consideration. As on today, there is no injunction order in that suit, Your Lordship. Since from 6 years, my application for conversion is not considered, and since from 2010, I have purchased this property, and since from 2010, there are several suits have been filed before the civil courts, and I have succeeded in all the suits. I have placed all those judgments also before the Honorable Learned Single Judge, and the Honorable Learned Single Judge has passed this order or by after referring to all those judgments. Your Lordship. He has no locus standi now before this Honorable Court, because this question before Your Lordships is, Your Lordships kindly turn to page 20, for opening paragraph of the order. That was the only question before the Honorable Learned Single Judge. As on today, he has there is no cause of action for him to file this appeal. It is for the Deputy Commissioner to consider my application for whether to permit to grant conversion order or not. At the earlier instance, in the suit filed by the appellant, there was an injunction order not to alienate the suit scheduled properties, Your Lordship. Later on, that came to be vacated, and they have not challenged that order also.
Who appears for Deputy Commissioner?
This is the order from, I appear for Deputy Commissioner.
Pardon? Direction is against you to.
Lord, the direction is to consider their application for conversion, my lord, as per page 35. Direction number 3, my lord.
Within 8 weeks.
I'll secure instruction, my lord, about the status of the application.
Take.
25th.
An undertaking is given by the government advocate, and he refers to some orders of the Honorable Supreme Court
That has
not
no
aware. He
relevance
has
to
to
this
clarify that whether
schedule at all. That has no relevance to this schedule at all.
Revenue documents pertaining to the land concerned stands in whose name?
in my name.
My lord, it was in the name of the subsequent purchasing.
As of now, revenue documents pertaining to the land concerned stands in whose name?
My lord, I'll have to verify that, my lord.
What verify? It's in your name?
In my name.
If,
Since from 2010.
if it is in his name, then there should not be any impediment for the government to consider his request for conversion of land. A decision will have to be taken in accordance with law.
My lord,
Even cause of action may arise.
if I may be permitted
after
to make two
granting
submissions. my
conversion.
lord.
You may have a right over the property concerned. That is a different thing altogether.
If I may make one submission, my lords. With respect to the way the property has been purchased by respondent number 6 vendors is through a fraudulent GPA which has been questioned, which became aware of it only pursuant to the writ petition being filed. Now that GPA is also questioned before the trial court, which is still pending adjudication.
Now listen, why was the writ petition filed?
My lord, no, the writ petition was filed was because that they were filing this application for conversion. My lord, if your lordships could take their application, I became aware.
Now, who
of
filed the writ petition?
Respondent number 6
Respondent number 6 filed the writ petition.
Please.
What is the prayer made?
for conversion of the land. my lord.
For
To set
conversion
aside
of
the
land.
endorsement and convert the land.
For conversion of the land.
Please.
And writ petition has been allowed.
Please, my lord.
You came in as an impleading applicant.
My application came to be rejected.
Your application came to be rejected.
Uh,
Yes, we are giving the liberty to the state government to process the application in accordance with law.
Let's kindly have it at least on Monday, my lords. Because I'll make submissions on merits, my lords. Because the translated copies were unavailable. I couldn't obtain them.
Unless you have a right over the property,
My lord,
you cannot object to it.
I will.
That has to be declared before the civil court.
my lord,
Now, admittedly,
I'll establish my prima facie
admittedly,
right.
not in
before
these
this-
proceedings, counsel.
I
Admittedly, he has purchased the property, whether right or wrong. Subsequent to the purchase, he has got all the revenue documents changed into his name. If you have a right over the property, you are required to file a declaration suit. After purchasing the property, he requests for conversion it for non-agricultural purposes.
my lords,
And your impleading obligation gets dismissed. Where is the question of entertaining your writ appeal and passing an interim order in your favor over here?
which is why I have filed an application for permission as well, my lords. I've also filed an application for amendment.
If you have a right over the property, that right will be granted to you, but you can't thwart him from getting the land converted under the given
Only
facts and
seeking
circumstances.
time till Monday, my lords, to make submissions on merits insofar as my prima facie right over the property is concerned.
Disposed of.
My lords, humble request to kindly have it on Monday, my lords. My humble request, my lords.
27th at 2:30.
My lords.
27th.
Grateful, my lords. Interim order till then at least.
What interim?
For the
undertaking was
state
given
not
by the
to
vendor
process the application.
That they will not proceed with the.
It is granted?
It is granted, my lords.
No, this is the observation. An undertaking was given by the.
December 24.
31st of December, my
December
lords,
24.
2024, my lords. Order passed by this court. And subsequently, it has been extended, my lords.
Whatever. 10th. Whatever is there. 10th will not grant for the time. Whatever is continuing, we continue, since it is adjourned. Whatever order continues, shall continue to operate till the next meeting.
Grateful. My lords, 27th, my lords. Grateful.
Macho.
Number 63, Mr. B. Ramesh.
There is a delay in filing. There is a delay of 72 days in filing, Mala.
Service is not effected.
Lord, service has been completed, Mala.
Completed? Yes, who will be there?
Respond number 12, Mala.
In respect of Mala, service has to complete in respect of respondent number 7 to 11, Mala, who are none other than the vendors of respondent number 12, Mala. So I'll serve it on the advocate, Mala, Ravi Shankar S. Mala. I'll serve it on advocate S. Ravi Shankar. Let's see, date.
Due date, so. 3rd March.
Much.
Number 64, Mr. Deepak Bhaskar.
The Lordship of the petitioner. Was this petition deals with the unregulated commercialization of an industrial, of a purely residential area in Bangalore. On the previous date of hearing, my lords may recall the learned counsel for the BBMP stated that they were unable to prevent this commercialization because they apprehended a law and order situation. And my lords had directed the BBMP to place on record what action had been taken. My learned friend undertook to file certain translated copies of show cause notices.
My lords, I appears for BBMP, my lords. My lords. My lords, senior is in another court, my lords. A translation copy has been already readied. My lords may kindly pass over. Unless my lords may we file it in before registry, my lords.
To be listed on 28th of March.
28th of March.
Grateful, my lords.
Number 65, Mr. Nagendra M.
Lords, I'm filing statement of objections on behalf of the state, my lords.
File in the office.
Please, my
Nobody
lord.
is present. It is 65.
65.
Stand out to 5th March. at 2:30.
Seal number 66.
Filing compliance affidavit, my lords.
Time may be given. A week's time may be given.
Filing compliance affidavit, my lords.
My lords. The regular council is held up in court on 15, my lords. A week's time may be given.
Date will be according to us.
Yes, my lord.
Yes, next.
67 urgent, seal number 68, Mr. Manmohan PN. 68.
In this matter, I appear for Union of India.
Not insofar as writ appeal number 938 of 24, which is filed by the employees. My learned friend has already taken notice. So Rajendra has taken notice for the second respondent. Insofar as his appeal is concerned, on the last occasion I pointed out the company has already passed a circular saying that it is implementing the order of the learned single judge. And we had filed a writ petition before learned single judge challenging that circular. Now, simultaneously, they file a writ appeal, challenging the order of learned single judge. In fact, said, ask them to clarify as to how they can file the writ appeal and simultaneously say that I'm implementing the order of learned single judge. So kindly see, my application for production of additional documents. I produce a circular note that they have issued. Can I request please turn to the application note which is filed on 23rd of September. IA number 3 of 2024.
Who appears?
Not Mr. Rajendra appears.
I am for the second respondent.
I'll reply.
But now, what they have done is, they had filed a memo, saying that they'll withdraw this appeal. Now, in the registry, they are saying that, we will not press a memo for withdrawal of the appeal. In fact, said, ask them, how can you pursue both on the last occasion?
28.
Please.
28 of February.
Please.
Case number 69.
Can I request on 3rd of March, subject to Lord's comment? 3rd, great. Please.
Number 69, Mr. Urgesh V. Charity.
But I appear for the appellant in the appeal. The appeal is filed by the Bangalore Development Authority, but there's delay in filing the appeal.
Notice.
But they
Actually-
have, he has appeared. Few of the
Actually, I
other-
have already filed counter objection to main appeal and also for IA, my lordship.
other
The
respondents are-
petition, the respondents 2 to 7 are wandering from pillar to BD office since from 2004. This is the third round of litigation, my lordship. Actually, may kindly see the writ appeal. The first writ petition was filed by respondent 2 to 7 in the year 2004. There are several directions issued by this honorable court to delete the small packet of land 34 guntas, which is, there is no layout at all, BDA layout surroundings. This honorable court has passed an order directing to make joint measure. Under joint measure also, the officials of BDA stated there is no BDA layout at all. North is abutted by the Gram Tana, and also the south side, it was left deleted by this honorable court. The entire surroundings, there is no BDA land at all. This honorable court has also specifically made a question. Is there any land, BDA land surrounded, and what is the distance? For that also, the officials of the BDA has given a clear Mahajar report stating that there is no entire surrounding land. Therefore, after observing all the Mahajar report, this honorable court has passed an order to exclude that land from the notification, my lordship. And lordship may kindly see, the writ appeal is deserved to be dismissed with heavy cost, my lordship. Lordship may kindly see page first. We have constructed the poor farmers are residing in that village since from 2002. That is before passing of the preliminary notification. I have produced the valid license, taxpayer receipt, everything. They themselves have presumed in the writ appeal, lordship. May kindly see page 67. From 57 to 75 are all
license to construct the building that was issued in 25/3/2002. So after obtaining license, the poor farmers have constructed the houses and they are residing. Even by the Mahajar report says, the Mahajar report of the officials of the, kindly see the order lots passed by the single judge. Now they are stating that possession has been taken. When the Mahajar itself says possession not taken, they are residing. Houses were constructed. And also, my lordship, they
Are
have
you-
said,
Are you appearing for 5 to 7 also?
lordship,
Are you appearing for respondents 5 to 7 also?
yes, all the respondents. I filed wakalat, my lordship, and also filed counter objections. It is available in the file, my lordship.
So what is to be done?
Not- There's a delay.
Delay is there.
There's a delay of
62 days. delay.
62 days in filing the writ appeal.
That there is no valid reason shown because the order passed 1 year back, my lordship. That is, they know well over of the, but I have given several representations. I have produced in the, along with my contempt petition to delete and as per the order. They kept quiet, they sleep. Being a body of the government, if it have any, they have to file within time, my lordship. Here, the Mahajar report, the commission, the engineers itself given, the court itself has passed a specific order to make joint Mahajar. Our Mahajar report is also available in the file, my lordship. Therefore, the writ appeal is deserved to be dismissed heavy cost, my lordship, because there are several decisions of this honorable court. When a small packet of land, there is no other BDS found any layout. This is very clear. 2 times they made Mahajar, my lordship. Once they said giant Mahajar, they had given. And again, the honorable court, lordship, you yourself has paid a question. What is the distance from the any layout? For that also, the second time, the officials of the BD has given a clear report. On the basis of that report, the honorable single judge passed an order. Lordship, kindly 2004, we have came before the court. 3 times this court has given direction from 2004 to delete the land. Unnecessarily, they are dragging, filing one after the other. And for the second time, we are filing contempt petition, my lordship. Earlier also, we have filed contempt petition. For contempt petition, they have not given any reply. Therefore, my humble submission, my lordship, to dismiss the writ appeal with heavy cost. There is a clear Mahajar report for the officials itself. How can say possession has been taken? There is no 16 notification. Gazette notification illa. I mean, they have not issued any notice to the landowners who are residing in the house. Simply some witnesses, they have made a Mahajar report stating that 4 witnesses, there is no addresses, valuable address also. There is no 16 notification, 16.2. Government has not published at all. And they themselves said, and the BDS passed a resolution after writ petition was passed in 2004 giving direction. As per the direction, BDS passed a resolution, my lordship, to delete the land and recommended to the government. The government kept quiet for 5 years, not passing any orders. And one day, the government has passed an order saying that Google report says there is no buildings. Hence, your BDA recommendation will be rejected. How can they, by seeing only Google, with the commissioner has made spot inspection and he has reported, therefore he has passed a resolution without deleting the resolution. And also, though they have made themselves has recommended by passing a resolution, and the village is there, abutting the village, the small packet of 34 land. South side, this court has already deleted. And the entire side, there is no BDA layout at all. The report clear, twice they given report, and commissioner also given a report. In spite of it, now they have filed this writ appeal. It is deserved to be dismissed with heavy cost, my lords. They are poor farmers. They also come before this court, honorable court. There are 6 ladies, very aged ladies are residing, and 4 farmers also residing the same house. The Mahajar report clearly says, since from 2002, there are buildings. The entire small packet, entire surroundings, there is no BDA layout at all. In such being, this is how can they deserve to file this writ appeal, even knowing that, my lordship.
may kindly see, my lord.
What is the extent of land?
Please, 34 guntas. Para 30, my lord, agreed by para 13. Lordship, what has been argued till now is that the possession is not taken. The drawing up of a Mahazar is a fabricated.
Now 34 guntas,
Yes.
it's not adjoining any,
Lord, it is abutting the main road. It is abutting the main road.
it's
But
not part
your-
of any layout.
No, your lordships have held, your lordships have time and again held, once the land is vested with the authority, my lord, even if the scheme lapses, the acquisition will not lapse.
Yes.
My lord, para 13 of the Leonard Single Judge's order, where there is a direction given to the Bangalore Development Authority to restore the possession back to the landowner. Lordship, may kindly see this paragraph, para 13, where there is a direction to restore the possession back to the, that means the petitioner has accepted the finding of the Leonard Single Judge where the possession has already been taken by the state government. But even if the scheme lapses, insofar as the entire layout is concerned, way back in the year 2006, this honorable court,
Preliminary notification date,
Lord, 2002, Lord, may, Lord, may I, 7/11/2002, Lord.
Yeah, condom. Delay is condom.
Please.
Appeal, when shall we list?
Any, after, any day,
20th March.
please.
Lordship suffering from 20 years, my lord. You may have it tomorrow 2:30, my lordship. I will, because since from 20, very poor farmers are residing. This is the fourth round of litigation. 2 times we have filed contempt petition. Before 2002, they have constructed the building. There is a very clear report is there. The single judge without, by mistake it has stated, we exclude land, restore possession has been
You want,
written in the judgment, my lordship.
you want early?
Lordship.
You want early? Early date you want?
Early date, I want early date, my lord.
Early date, all right. So when shall we keep, but 11th March?
Next week, just kindly next week, 2:30 it may be,
All right, 25th,
any 2:30 matters may be fixed, my lordship.
25th February.
Much obliged. 25.
So 25th, 26th or 27th? No.
24th.
Obliged.
Bill number 70, HP Leeladhar.
Here also 78 days delay.
R4 to 6, sir.
Four to six are not solved. Pardon? Number 4 to number 6 are not solved.
Yes, so far 6 is concerned, you have filed dispensation application. 6 you are concerned, you are dispensation application I filed.
Dispensing?
Yes, sir.
Why?
I filed it. Already filed it.
You want to dispense? with-
No, not necessary, you are, but they are the petitioner earlier, but they have not challenging that.
No, you delete, you will not dispense.
Yes,
with
sir.
the
I will delete.
Learned advocate for the
I will delete.
appellant wants to delete this number 4 to 6.
Yes.
They are deleted from the area of respondents at the cost and consequences of the petition. So delay gone down.
Delay.
Madam, delay is.
Yes, it's IP for respondent number 3 BD, no objections.
So now appeal will be on some other day.
Oh, yes, sir. Date may be
20th March.
much of this.
Great.
Bill number 71.
I have served the copy to the council who was.
Today I have filed wakalat on behalf of respondent number 3 to 32, Your Lordship.
I have served the copy to the council who was appearing before the learned single judge, my lords, as per the direction.
I have filed wakalat today, Your Lordship, for R3 to 32.
Need time.
I need time.
Date 28th of March.
Bill number 72. State appeal.
For the respondent, to my lord.
Nobody is there, 28th of March. On that day will pass. Let him, he will not know otherwise.
Bill number 73.
23, I have paid the PF, my lord. Meanwhile, my lord, I am permitted to take the notice to the penal council, my lord. Seeker Jai Govind, my lord, for R2.
What is the request?
My lord, I will permitted to take out the notice to Seeker Jai Govind, who is a penal advocate for R2, my lord, who has appeared in the writ petition also.
You are there, Mr.
My lord, I appear, my lord, for the college, my lord, which has been, UGC has said, my lord, we are entitled to, my lord,
This can wait, nobody is there. Any urgency?
it will, my lord, because the academic year will start from
So 11th
March.
March. So then
11th March.
4th
Please.
March. 4th March.
Grateful.
74.
My lord, I am appearing for appellant, my lord. My lord, I'll have to take steps in respect of respondent number 3. My lord, a week's time may be granted, my lord.
Grant 18th March.
Please.
Number 75. K. Krishna.
Already served the copy to the council who appeared before the learned single judgment. Their name is also shown in the, because I already served the copy notice to the council who represented before the learned single judgment. Their name is also shown in the.
I appear for R1, my lord, and I undertake to file Vakalata on behalf of R1, my lord,
26.
and seek objections.
76 is urgent. 77. Timothy Lena Abraham, party in person. Timothy Archana KM, the advocate in contempt matter 11/23 of 24.
Give some date.
78 is urgent. Number 79. H.N. Basuraj.
You are appearing for the appellant. First matter.
Lord, in 79.2, I appear for the appellant, my lord. Some office objection, my lord, concerning, my lord, production of legible copy of page 16 to 75. Lord, there's an order sheet maintained by the learned single judge. That is not required because in a connected writ petition mode application.
You want dispense with?
Yes, ma'am.
Office of the dispense.
Will be listed next week. It's related to
Monday, ma'am.
elections to the Election DCC plan. The order of the single judge's complaint would have been completed about 4 months ago.
25th.
27.
25th.
25th of July.
All these three may be listed in preliminary hearing.
Number 80. Mr. Dhananjay Kumar. Number 80. Mr. Dhananjay Kumar. Office objection with council submission. '81 is urgent. Number 82 for final disposal. Mr. Venkatesh Somareddy.
After some, my lord, there is already an order by.
19th March.
Maybe it could be little later, my lord, because, my lord, it could be bit later, because in a connected matter, my lords have already passed an order that it reads WP 4829 of 2018 involving legality of the tender process shall be considered subject to the outcome of the above directions. Certain directions were given in WP 31676. So after it is considered, then only this writ petition is to be, therefore it could be little later also. tender process.
It's infructuous.
No, madam.
This virtually it has become infructuous. This writ petition has become infructuous. And
Short accommodation for 2 days, my lord.
Two more, two.
Please, my lords.
Number 83, Mr. Narayan MR. The final hearing. Number 83. Number 84. Mr. Krishna Nedungadi.
Being in the connected matters, this is regarding the entrustment of the statutory job of registering of the vehicles to private individuals, my lord. That has been questioned in the writ petition. Other side was taking time, that the learned additional advocate general will be appearing in this matter, my lord. I have filed the synopsis also pointing out the relevant provisions which are violated. I have filed it in 2022. They have
Lordship,
Take
may
up
kindly have it
taken
next
time,
week
my lord,
sometime.
any day convenient to the court.
21st March.
Grateful.
Interim order to continue. In my case, there is an interim order.
Interim order will continue to operate. In 84.1.
Till further orders ಆಗಿದೆ. Further orders ಆಗಿದೆ. Next date ಯಾವ್ದು ಇಲ್ಲ. Till further orders ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ಮತ್ತೆ ಕೇಳ್ಬೇಡಿ. Problem ಆಗತ್ತೆ.
Okay, thank you.
11/21 ಅಲ್ಲೇ ಆಗಿದೆ. Till further orders ಆಗುತ್ತೆ.
Madam, serial number
82
47.
Madam, ತಗೊಂಬಿಡಿ ಮೇಡಮ್. 82, 28, 29. ಹಾ. ಒಂದು ಮಾಡ್ಕೊಳ್ಳಿ. 47 dated. What is it?
I'm not in obligation to tell the dates now.
18/3. ಹಾ? ಅಲ್ಲಲ್ಲ. ಈಗ ರೀಚ್ ಆಗದಿರೋ ಮ್ಯಾಟರ್ಗೆ ಡೇಟ್ ಹೇಳ್ಬೇಕಲ್ಲ, ಅದು ನನ್ನ ಪ್ರಾಬ್ಲಮ್. ಅದಕ್ಕೆ I'm not in obligation to tell the dates now.
58, 56.